Mentioning.
Let me mention on matter, my lord. This is related to the illegal construction of the temple, church, and others on the roadside and the public places. There was a direction given by the Supreme Court.
So we take up mentioning on Thursday, Mr. Chakraborty. Give a notice and come back on Thursday.
Kamala, this is court also suo motu issued notice in view of the judgment of the Honorable Supreme Court. Honorable Supreme Court referred the matter to the High Court, for all High Court, and with the direction that High Court should ensure that the order of the Supreme Court passed, several order passed regarding the illegal construction on the public road, public place, and others. So a contempt petition was filed that was pending, and another writ petition was filed that was pending. And High Court suo motu, this is the order of the Supreme
Court. Come back on Thursday, Mr. Chakraborty. Yes, what?
With notice to the other side.
Not mentioning today, sir. We have indicated in our list. Yes.
Appearing for item number 1.
One, my lord. Item number 1.
Yeah. Call the list.
Response number 17.
Will I appear for the respondent number?
Very short passover.
Item 1.
Item number 1. Will
I appear for the respondent number 13 and 14.
My lord,
Respondent, who is for the
I am for the petitioner, my lord. My lord, this is that matter where your lordship remembers with the Bodortola bus depot, my lord. Bodortola bus depot, there was an unrest because of which one of the commuter has come up before your lordship. The main objection which was raised by my friends, my lord.
Other matters.
Yes, there are other matters. Now, my lord, it fell from your lordships that your lordship will observe to the effect that we will be at liberty. I will be at liberty to come back if such unrest is again found at such bus depot, because there are certain civil issues which are to be taken care of, and all the points will be left open. That was the last thing which happened on the occasion this matter was heard out. My lord, there were 2 points, my lord. One is that
pointed out to you that pertaining to the issue, different matters are paid. Now, on that context, we said that you withdraw the petition. But you were out not with instructions on that day. We said that as 3 matters are pending, it is not an issue to be urged in a public interest litigation. Suppose if anything different happens, that will not debar you from coming back to us. If a new cause of action arises, you can certainly consider. But how can we, madam, in a non-acceptable petition, give you a liberty?
My lord, only thing, my lord, 3 applications are not pending. One has already been disposed of as want of jurisdiction.
You have applied your mind, but the issue is the same, pertaining to the same land. So if you withdraw the petition, does not prejudice you any manner. But if you want us to give a return to your finding, then we have to go into the points and say that litigations are pending. On that count, there is no public interest involved, at least in this matter, to be taken up suo motu by the court.
My lord, there is also another issue, my lord, which is a public fund largesse, my lord. That is also because it's a property worth rupees 132 crores.
করছে না মামলা
তাহলে withdraw করছে।
My lord, our preliminary point, my
Then your lordship
is a
will kindly hear us on demurrer, my lord.
Withdraw, madam.
Withdraw, otherwise we shall,
Then your lordship will kindly hear us on demurrer.
যদি ম্যাটার
Yes.
প্লেস করে
we have to dismiss because of the
Yes.
fact they are
Mr.
maybe
Mohit,
my lord, withdraw with liberty to file afresh if similar situation arises.
But I am never agitated, my lord.
if the
Lordship knows me
person
by
who
now.
filed the writ petition did not get his desired result, they can approach the division bench.
They can, but how
My lord, the
They
petitioner
can
before.
approach the division bench এবং even they can go to the honorable apex court also.
No, I really don't want to get into that, my lord. Whatever was discussed on the other day, my lord, after I made the submission and whatever came from your lordship is that, my lord, the petitioner will have a liberty to file afresh, even agitating the same self grievances if there is an unrest or whatever the situation is, my lord. My lord, I am kindly disposed of with such liberty because already, my lord, that public unrest issue has been taken care of because there has been an order of Justice Single Bench in the police in action matter for strict vigil. Based on that, my lord, that issue is over.
তখন আসবে পিআইএল কিছু ডিপার্টি
বলে কি যশের দিক দাঁড়ায়।
To come up with a similar public interest litigation if so
Pick out
required.
that case at that juncture, madam. Pick out that case.
My lord, because we had come up in twofold issues.
I try to analyze this withdrawal will not debar you from taking up a thing which occurs in future.
My lord.
No,
But my lord, there is
Yes,
another one, my lord.
Liberty is even on the to file a case on the same cause of action. So if any order pass, then the cause of action will not be same. A different cause of action will arise.
My lord, only thing, my lord, only thing.
Okay.
My lord, there was
oh,
another
madam,
issue.
it is okay. Be the file
As
on the prayer.
on the pair of the
led by Mr. Kamalesh Bhattacharya.
He has some personal difference. Take tomorrow, my lord. Only
That
not,
report
only
has
not
come.
today.
Report, we called for any report.
My lord, report already, my lord, submitted.
My lord, already instruction has been submitted, my lord.
Yes, my lord.
Then
On
Only
previous
tomorrow,
occasion we have
today,
submitted.
my lord, not today, only tomorrow, my lord, I will take up some.
person.
Conversion, no
My
conversion.
lord, Brickfield permission was there, my lord.
Oh,
Every necessary permission, my lords pointed out.
yes, yes.
But
Every sort of, as per our report, my lord,
Come to
pollution
conference.
control board, every
Okay,
permission was there, my lord.
Not today, yes,
Not today.
next.
Grateful, my lord. In a report. Nothing to.
I appear on behalf of the petitioner.
Lord, I beg to appear for the private respondent.
So this is the second round of litigation. Initially, there was another public interest litigation in which state appeared and they submitted. This is regard to filling of a pond, which is recorded as DOBA in the records of right. Now, in the
Yeah, give us 2 minutes time.
yes, Lordship, kindly peruse the last order passed by your Lordship.
হ্যাঁ হ্যাঁ কি বলছে আরে এগুলো বাবা
My lord, it was filled up. Criminal case started against the wrongdoers, my lord. They were arrested. Now BLRO and BLRO has issued a direction to restore the pond in its original.
but that was earlier also done.
Earlier, it was
My
done.
lord, this is that necessary instruction has been issued to restore the pond, my lord.
Yes.
Yes, restore the possession at their own cost. Otherwise, the state will restore the same.
My lord,
Cost will be recovered from them.
The private.
Yes, yes, my lord.
Provision
I
is
will-
there.
Yes, yes, we
Now,
will.
what step you have taken?
my lord,
Now,
I'm beg to appear for the private respondent. My lord, two things, my lord. First, my lord, I'm on the maintainability of the public interest litigation, my lord.
That
They
you
ought to-
cannot take, na. It is consequence, a sequel to the earlier public.
Yes. Now, difficulty on the merits, my lord.
You are
my-
that landowner.
Yes, no, my lord, on the earlier occasion, my lord, what had happened, my lord, the property stood transferred, my lord, after conversion, I purchased the plot of land. Now they have come up against the wrongful conversion. Now after conversion, my lord, I have purchased the land. So whatever falls upon the private respondent, or he is not made a party in this proceeding, my lord, he is my predecessor in interest. I purchased the land after conversion.
He is out of the scene.
Yes, that is the
Now you
difficulty.
are the, now you are will be the
Now,
sufferer.
Now, difficulty is
It is
this
a
one.
open, it is a vacant plot.
It is a vacant plot. I have not made any construction, and now I had purchased the land upon conversion. It is not that it was DOBA.
You take steps against your predecessor.
But
How
did
he could have sold this land, changing the character.
No, he had changed the character. He has changed the classification in the land records. Thereafter, my lord, I have purchased.
Then conversion was not done.
He has come up against that illegal conversion. According to him, the conversion ought not to have been done by the land revenue authorities.
no, land department also said that conversion was not legal and proper, and hence the
But
concerned
I am a
department,
subsequent purchaser.
concerned department passed, issued direction for restoration.
But I happen to be a subsequent purchaser.
peruse.
When you have purchased,
But I have purchased much
Lordship, kindly peruse page 26.
On
That was the earlier
of
and
May
page
2024.
with page 28.
2024.
the direction was given for restoration in 2020. After 4 years, you have purchased.
My lord, my
Direction
predecessor,
was given by from the concerned department to restore it in 2020.
my lord, my predecessor
That
had,
direction was in force when you have purchased.
but difficulty is this, my
The
lord.
conversion is in question, was in question at that time.
Lordship, for once, Lordship, kindly peruse page 26 and compare it with page 28. Page 26, when it was Doba, there are water body. Lordship, kindly for once, page 26 with page 28.
You purchased it from Arham Ali.
Yes, my lord.
You are Madan Mohan Rai, Suparnova Roy.
Manoshi Rai, Somen. Yes, my lord.
You are respondent number.
20 and 21, my lord.
What are your names?
Abran Ali.
Manoshi Roy is 19.
So Arham Ali purchased. You are for Arham Ali.
My lord, I purchased from, yes, I am Aram Ali and Abhiram Ali.
Arham Ali and I respondent.
Afrahim Ali.
Four.
Yes, 20 and 21.
20 and 20. Just a moment. You are 20 and 20. You purchased it from whom?
My lord, I purchased it from Manoshi Rai.
19.
Manoshi.
Respondent number.
Manoshi Rai.
Oh, and who are the Shobharani Moitra, Madan Mohan Rai, Suparnova Roy? They have been issued notices. Are you charge sheet against Adam? Found there are residential boundaries surrounding there. However, there is no road on either side. Entire portion is covered with dense jungle. কতটা measurement এটা? Then what did the now BLRO, what he has done? Has he initiated steps?
Lordship, nothing has been done. Lordship,
In this information it is given on 20th August 24 a communication on 6th August 24 BLRO made a communication with the PS that he issued. Did the BLRO now initiate any proceeding, Mr. Mishro? Mr. Mishro, don't give detections only upon the inspector in charge. They are law enforcing authorities.
My lord,
He sent it to the BLRO.
yes, my lord.
And matters he has to come. Now, what page 26? What you are showing?
Lordship, page 26 is the original picture when the water body was there.
Yeah, just a
And kindly, Lordship, compare it with page 28. The backgrounds
has
are
been
as it
filled up.
is.
Now it has been filled up.
Yes. And it has not been restored till date.
And show us the earlier order of the court.
Lordship, the earlier order of the court is at page 40.
Page 40.
Yes, 40 and 41. The situation which was in
Just a-
2024.
Just a moment.
Yes.
Process of restoration is continuing. Directed. Initiate a proceeding as per 51F. There had been no development thereafter.
No.
Now this quoted portion, this is order of BLRO.
Lordship, it was on the report. Based upon the report, that portion has been quoted by their Lordships.
Process of restoration is going on as per law. BLRO has been directed.
This was quoted from the report of the ADM and DLLR.
Initiate a proceeding to restore. Yes, Mr. Mishro, then what had been the fate of this? Did you initiate any proceeding?
My lord, kindly grant us a week's time, my lord. What has been done by BLRO?
Please come to page 40, Mr. Mishro.
Yes, my lord.
Page 40, that ADM report.
Yes, my lord.
40, it is quoted in the order of the court. See the process of restoration of suit plot
Yes, my lord.
and is going on as a, in this year BLRO has been directed by a memo of 16th August to initiate a proceeding as per provision 51F. 51F.
Now, my lord,
51 একটা হচ্ছে ওই নাম চেঞ্জ করা, হ্যাঁ নাম চেঞ্জ করা একটা রেকর্ড অফ রাইটস এর নাম, হ্যাঁ
Section 50
51 on the basis of their
now, my lord,
50 within bracket 1 within bracket 8 on the basis of নাম চেঞ্জ করার জন্য মিউটেশন। এই যে 51 such other causes as necessitated a change in the record of rights, বিক্রি করলো মারা গেল তখন যেগুলো মানে ওই নামটা ওনার নামটা হি পারচেজ দ্য ল্যান্ড and hence the name, no you you read the 5B and 4C, 5B and C.
my lord.
Now your course is you will give him a time, certain reasonable time.
My lord,
You restore his of his own.
my lord,
Otherwise, you restore and recover the cost
From the person responsible.
my lord,
and that would be, if he fails to pay, that would be public
my lord,
recovery.
pursuant to that direction, my lord, if my lords may kindly take the instruction, my lord, which I have just filed, my lord. Second page, my lord. My lord, I have gone through the.
Yes, second page.
My lord, pursuant to that order, my lord, if my lord may kindly take, my lord. 1, 2, 3, 4, 5. My lord, kindly see, my lord, sixth paragraph, my lord. It is also apt to mention here that on 6th of August 2024, the PL and BLRO MJ Block Murshidabad made a communication with the
That
PS.
he is not required to. He made a communication to police station.
No, my lord. My lord, kindly allow me to place the entire line, my lord. That he issued a notice. That BLRO has issued notice to Shobharani Moitro, Madan Mohan Rai, Suparnova Rai, Arham Ali, Afrahim Ali for immediately restore the suit plot to its classification through his office memo bearing such and such dated 6th of August 2024.
Then what happened there?
My lord, in 6th of August 24, my lord.
24, we are in 26.
My lord, kindly give us a week's time. What is the present status? BLRO, I will ask the BLRO to submit a report on that, my lord. That after this, my lord, after this memo that has been issued to restore, my lord, what has happened, my lord? Kindly allow me a week's time, my lord. I will come up with that.
That was already there in our earlier order. Records reveal that the petitioner
In this matter, this leads to me that the declaration of heritage, I believe Mr. Double AG would.
My lord. Well, so far as my lord, the building situated at 9 Jawaharlal Nehru Road is concerned, but I have taken specific instructions that building belongs to the Life Insurance Corporation of India. Now, the LIC, well, they have given specific objection as against conservation because their case is, my lord, that it cannot be, my lord, repaired. It is beyond repair. In fact, my lord, there were a number of series of writ petitions which were moved, where, my lord, the honorable single judge had directed the LIC to hand over a copy of their plan for reconstruction to the petitioners who are occupants of that particular building, my lord. The difficulty in so far as, my lord, this public interest litigation is concerned is, my lord,
What is the problem? That land which has been earmarked, that is to be developed by Heritage Commission.
no, but this pertains to, my lord,
So
preservation.
what is your grievance?
That we want that the heritage declaration of these old city buildings. Whether this is whether occupied or not, the building should be declared as heritage building. It doesn't depend on whether it's repairable or irreparable. If it is declared as heritage, then that should be preserved under the Act by the Heritage Commission with the assistance
Which
of
act? Which act?
the West Bengal Heritage Commission Act.
Now then, what is the role of KMC, Mr. Bhatt?
KMC has a heritage committee. They have to decide.
The committee, no, commission is different, my lord. Heritage
Commission
commission.
is by the state.
Yes.
KMC has a heritage committee. They will determine, identify, and declare.
I see. So any decision to that effect has been
I'm
taken?
not sure. That's
But
what
it's an ongoing, my lord, saga, I will say, because, my lord, there have been a series of litigations, series of orders have been passed, there have been objections by the owner of the building. They say that it is not a heritage building because it has no aesthetic speciality. So, but unfortunately, my lord, LIC has not been implemented as a party respondent. In fact, my lord, there were meetings and deliberations where, my lord, the representatives of the petitioner, they were also present in the meeting.
may I give a suggestion? No,
Then
this
you
is not
come-
adversarial. Let the KMC, my lord, decide whether they are willing to declare or not. What are the reasons we can support? And give them the, my lord, the intellectual support to get what's declared.
But Mr. Bhattacharya, if it is some persons are possessing the property,
It's
then-
immaterial.
Huh?
It's immaterial. Because here the occupation is the factor. Factor is not the heritage structure. The structure, my lord, is the oldest structure in the city, my lord, it's the heritage impact. It would not depend who is occupying, who is owner. It doesn't matter.
No, it is a building.
Yes.
Yes.
So very
That
old,
is being
oldest
occupied.
building.
Pardon? Pardon?
Oldest building in the city.
Which is this building?
The 9 Jawaharlal Nehru Road, which, my lord, they say is owned by the LIC. That even then this becomes not the responsibility of the LIC as a public organization to protect it and preserve it.
What I was humbly
তুমি একটা
suggesting,
রিপোর্ট আমাকে দাও কপি দেখে নি
report এখনো তৈরি হয়নি, instructions নিয়ে এসেছি।
কিন্তু সেটা
আমি
বলো
report
তো
করে, হ্যাঁ, একটা LIC কেও party করে দিন তো তাহলে।
LIC ঠিক আছে সেটা
তাহলে
আমরা
court LIC কেও, হ্যাঁ।
এটা দেখে নাও আমরা রিপোর্টে দেখিনি কেন এর তো এক্সপার্ট বডি দেখিনি
সমস্ত হচ্ছে হেরিটেজ কমিশন দেখবে
So silent, sir.
But there is no prayer against me. All the prayers and the allegations are against the Heritage
So you will,
Conservation
or
Committee
you
of
will,
James.
you act only when a prayer is made to you, sir.
The
Do something
representation
for
is
us.
also not made before the Heritage Commission. This is
Nobody approached you.
Nobody approached you.
61A, the representation, that was also made before the KMC's Heritage Conservation Committee, not the West Bengal Heritage
Now
Commission.
you tell us what is the procedure adopted by your commission. Suppose if
Once an application is received, well, it has its own guidelines as per the
once an
application is received to the effect that this could be included
as an
they
heritage
process-
building.
yes, madam, they process and their own guidelines as per the statutory rules laid down in the statute and the rules framed thereunder. And thereafter, they call for
So you do not consult the Heritage Commission of KMC, that
Heritage
committee.
Conservation Committee. No, madam.
Committee,
This is an
sorry.
independent statutory authority. If an
We
application
understand. Do you have any procedure to call for reports from the committee of the?
that is there because if well, these are overlapping, well, there are overlapping jurisdictions between the Heritage Conservation Committee.
No,
as well as
is
Heritage
it
Commission.
is it a fact that nobody contacted you to declare?
With
that is-
regard
that
to
is
this
not-
property, nothing. madam.
Nothing.
But kindly see page 261A, their representation, that is also before the Conservation Committee.
261.
A, 261A.
There were earlier public interest litigations also.
Yes, but there was a previous
45.
public interest litigation.
245.
This
there-
order-
Order is 245.
Paragraph
261A is
59, my lord.
254 is the judgment.
Yes, Lordship may kindly turn to page 259, the operative part. Paragraph 14 onwards.
14 onwards, well, kindly see. Heritage Conservation Committee.
This is pertaining to the same property, Mr. Bhattacharya.
But-
This page 254.
But that there are other properties including this. Because this is general application, my lord, for the purpose of
Then
preservation.
what
of heritage.
happened? What did the court direct?
Court directed, my lord, that state government will take necessary decision with regard to the request for approval of such rules made by the KMC, because KMC was taking a plea that there was no rule. As expeditiously as possible, since KMC is directed to upload the decision of the Heritage Conservation Committee with regard to the heritage building, it is appropriate that KMC uploads all decisions of Heritage Conservation Committee commencing from the inception of the committee in such website. It's a very wide my lord, direction. Rules দিয়েছে?
ড্রাফট রুলসটা তৈরি হয়েছিল মিটিং এর জন্য ল ডিপার্টমেন্টে গেছিল তাদের কেএমসি না রিজলভ হয়ে গেছে কোর্টে
Come, we want to have a final decision on this. That this is for the
Then you could have approached in contempt before against that order. That would have been easier.
that would not yield any result.
Pardon?
That would not yield any result. Moving contempt. We want
Certainly,
to
they would have come with all the reports and
let,
everything.
let
we
them
could have
also
been
now
passed
can
out.
come.
Now, then today we will pass a direction again. Tomorrow another writ petition will be filed.
That's why you want to have a conclusive decision. Let the report come before Lordship. Let us come to a decision that whether these buildings will be declared or not. And earlier also, this court at page 249 says that maintain the status quo till the declaration is made. It can be finally resolved. The Heritage Committee Chairman,
It is the Heritage Conservation Committee to decide whether a particular building will be included in the list or not.
That's their decision. This is the expertise.
After this, given reasonable opportunity of hearing, come to page 259.
Yes, that's the direction.
Division may directed.
Yes.
And the person likely to be affected.
Yes.
What further direction you want from us?
I want Milord to see the result of this.
For that, you should have gone up in contempt and compelled them to take action.
Milord, even if there is no content, Milord, for execution of the order, Milord, we can approach your Lord.
That is
That
but
is-
once you file a contempt and appear, naturally the person will have to appear and justify that why I have not done.
Milord,
That would be a more
all-
competent process.
difficulty, I tell you, Lordship, the change of, Milord, the guards from time to time, the officer will change, contempt will have no end to see.
Regarding the rules, my lord,
We
the
will simply call for a report and again keep the matter
No,
standing.
Lordship can call for a record and come to a conclusion. This is the final decision of the Heritage Commission. That will resolve it. So
That
that,
ought to have been the end product of the judgment of
that
the
has, since
coordinating.
the product has not come,
my
Lordship
lord, the
can't
only,
enforce.
only, my lord, stumbling block is, my lord, the draft rules were, my lord, made ready. They were sent to the law department of the Kolkata Municipal Corporation for vetting, my lord, so that it can be placed before the my lord, Board of Councillors. But my lord, in the meantime, my lord, the MCC, my lord, the Model Code of Conduct, my lord, that came into force for the elections. Now, as on date, my lord, the board has been dissolved. The KMC, my lord, is being run by an administrator now. So that is
Therefore,
the, my lord, as I said, my lord, the only stumbling
It
block,
can
my
be
lord.
done by the Milord administrator.
But you have, the committee is not there at all.
No, but the draft rules, my lord, regarding, my lord, there was
No,
another
the committee exists, na?
committee.
Committee exists.
Instruction নিয়ে বলতে হবে কমিটির মেম্বার কারা শুধু দেখো
চেয়ারম্যান ছিল দেখো কি একজন হিস্টোরিয়ান থাকেন চেয়ারম্যান।
সেটা আলটিমেটলি এই কমিটিতে বিষয়।
Purpose, Mr. Bhattacharya, it will be kept, just give a thought to it, Mr. Bhattacharya.
No, Milord, then this can be converted to contempt. What is the ultimate result? Milord, this is not an adversarial situation. But this is for preservation. Let the committee, Milord, now, which is, Milord, I believe the commissioner is under the head.
Sir, did any proposal, yes, sir,
No, Milord, Heritage Commission would have no role.
did any proposal from the committee reach your?
My lord, so far as these buildings is concerned, nothing. Even in the restriction, there are no prayers, no order was forwarded, no representation was made.
তো তাই জন্যই তো এখন করেছে ইনটেকের মেম্বার হি ইজ দ্য মেম্বার অফ দ্য পিটিশন এট ফার্স্ট ওয়ান অফ দ্য জাজমেন্টস
তবে কি হবে না
দেখি
also within the domain
তাতে
of
কি
the
আছে
committee to decide. ওরা তো একটা application করিয়েছে, the committee
But
should
as
consider
per
it.
my knowledge goes, Milord, this committee is headed by the historian who gives, Milord, the guidance of how it is to be preserved.
Bhattacharya, any committee is there or not, yes or not?
let me come back with instructions as regards my lord, the status of the committee as on date my lord, since it has been dissolved my lord, so that I can
We
come.
cannot pass any unimplementable
I
order.
completely
Now we
understand, my lord.
pass a direction, you come and say there is no committee, I will
No,
not.
my lord, may I, my lord, come back with a report, my lord, which I can also file, my lord. And in the meantime, if my lord, Mr. Bhattacharya also.
That direction we can provide, but if there is no committee present with the change of the political
Committees-
dispensation, I don't know.
I'll,
These committees do not change.
no,
We don't know
I
what has
cannot make,
happened.
my
Mr.
lord, a
Bhattacharya.
statement without instructions, my lord. As on date, my lord, what is the
So do
status?
we pass that direction upon you that you come with a report?
My lord can direct that, my lord, we can
So
file.
it is existing, then it cannot, their functioning will not be disturbed by the change of the political
My lord,
dispensation.
who were the members and all, my lord, as on date, my lord,
So that we asked you, Mr. Bhattacharya, on the last occasion on 1st July.
yes, yeah, check KMC.
Please assist us, please
Yes,
assist
yes,
us.
yes.
We passed a judicial order
Yes,
on
my lord.
1st July.
I completely bow down to that, my lord.
Technical information.
একটা KMC র কাউকে থাকতে বলবে তো না?
ওই ওখান থেকে এসছে, কেউ আসেনি।
Had Mr. Bhattacharya learned
correctional home and
We have said urging the issues at the
Yes, we have given the list. That
with
was
a
the specific
comprehensive
reference.
report, please file. Ask your officer to go through the writ petition. Yes. Yes, next.
My lord, for item number 5, I am for the petitioner, my lord, led by Ms. Ananya Yogi. My lord, on the last occasion, the last order was passed in 2022, my lord, in this matter. 22nd May 2022. My lord, the learned division bench had...
What is the ordered impute? Come to the ordered impute. You were dismissed in 1996. Is your client interested in the matter?
Yes, my lord, he is.
Then why haven't you taken any steps? You are also sleeping, your client is also sleeping. If there was a direction for affidavits immediately after expiry of the period, you ought to have approached the court. You did not ever mention the matter after 2022. Then, madam, what purpose will be served? Have you taken instruction? There was a dismissal. You preferred a statutory appeal, admitting before the court that those statutory appeal papers are forged. Recording that you approached the court in the original application, dismissal was in 96. You approached the tribunal 15 years thereafter.
My lord,
And the ground taken was your counsel did not assist you and did not appear.
Yes,
That has been negated by the court. Now, why into 2026? Why should we interfere now? Tell us. It was a dismissal from service, na?
Yes, my lord.
So dismissal for service, this OA, previously OA was filed in 20, this OA was filed in
15, my
that
lord.
is
2006.
2006. So what remains in this matter, madam?
My lord, the second...
Your senior.
Miss Ananya Yogi. Ananya Yogi.
Ananya?
Yogi.
Where is she?
She is in another courtroom, my lord.
We don't find any reason to interfere in this order.
My lord kindly keeps the matter tomorrow, my lord. She will appear in the matter.
Tomorrow you will be able to get information. মক্কেল নেই, মক্কেলই চলে গেছে কোথা থেকে।
My lord, order of dismissal is at page number 99, your lordship.
99?
99.
And where is your charge sheet?
My lord, charge sheet is at page number 49.
43.
49, my lord.
49. Yes. Why you are taking adjournment? You are arguing well.
My lord, I'm not very well versed in the matter, your lordship.
This is the first your appearance.
Yes, my lord.
In our profession, there is no learner's license. You have to start from day one. 44.
49, your lordship.
49, yes.
Have you preferred statutory appeal against the penalty, order of penalty?
Prefer করেছিল।
An appeal. When the appeal was disposed of, page.
Was the appeal disposed of?
No, my lord. The appeal is at page number 103, your lordship.
103, the petition of appeal, appeal petition. Where is the order? Appeal was disposed of by passing an order.
No, my lord. The appeal has not been disposed of.
Kindly come to internal page 6 of the order review. Please read the last paragraph, Roman 1. You have got it?
The applicant was dismissed by the
Yes.
disciplinary
Take the mic and read. Take the mic.
The applicant was dismissed by the disciplinary authority.
So 1996.
Yes, my lord.
Although the applicant claims that he had filed an appeal on 4th of October 96 and issued a reminder on 20th May, the respondents have categorically denied in writing that no such appeal has ever been received by the authorities. It has been wrongly written as revived. And the applicant has not been able to produce before us that any proof of receipt of the said appeal. Now, during hearing, counsel would candidly admit that Annexure A, it is a forged document, and he came to learn that an FIR has been registered thereupon. As the said OA and his purported instructions on the appellate authority in the context of appellant's appeal are all fabricated. It cannot rightfully substantiate that the applicant had approached the tribunal within 1 year from the date from the order issued by the appellate authority. Where is that order of the appellate authority? 4th of March 2014. Have you annexed that?
Yes, my lord. My lord, the appeal is at page number 103, my lord.
103.
Very good. 103. This was, you issued a reminder in 97. Where is that reminder?
My lord, the reminder is at 117, your lordship.
117?
Yes, ma'am.
Then where is your Thereafter, you preferred the original application.
My lord, thereafter at page 119, the erstwhile advocate has sent a legal note.
119.
19, your lordship.
Yes, what is that? 119?
My lord, the erstwhile advocate had sent a demand notice, your lordship, for disposal of the appeal.
What was the prayer? That you dispose of my appeal?
Yes, my lord.
Very good. Then what happened? You came to the tribunal.
Yes, your lordship.
Then page 121 is the tribunal order. What did the tribunal say?
My lord, here, my lord kindly takes page number 122, your lordship. Point number 3, your lordship.
Submission after perusing, we dispose of the original by directing respondent to pass the, that is the appellate authority order should be passed. In
Yes, your lord.
2014, that was the direction.
Yes, my lord.
Then what happened? Did they file any, did they comply with the order?
No, my lord. My lord, the petitioner, my lord, kindly comes to my writ petition, your lordship. My lord, at page number 4, my lord, point number 7. May I place your lordship?
Yeah, just. Yes, place it. What is it?
Your petitioner states that when your petitioner went to the office of General Manager, Metal and Steel Factory, Ishapur, your petitioner was told that the original application number 301 of 2008 was not the application filed by your petitioner, and on that OA number, no such order was passed. The aforesaid fact having been intimated to the Registrar of Central Administrative Tribunal, the Registrar order of my lord, the earlier order which your lordship.
So it is a very serious allegation.
Yes, my lord.
That no such original application was filed at all.
Yes, my lord. The original application as well as the order passed by the learned tribunal, my lord, it is alleged that they were
Those
false.
were forged.
Yes, my lord. By the erstwhile advocate, your lordship.
Why the advocate will forge?
My lord.
So what did you tell the police?
My lord, the police registered a criminal case against
what
the
is
advocate.
the status of that charge sheet filed?
My lord, kindly takes.
Then when this order was not complied with, you filed a fresh original application?
Yes, my lord. The 2015 original application is the fresh original application. Along with it.
Which year you filed the fresh original application?
My lord, that is in 2015, your lordship.
2015?
Yes, my lord.
And the order impugned you have assailed here?
Yes, my lord. My lord, the learned tribunal, there was an application filed for condonation of delay, my lord. The delay has been of 8.5 years. And
delay, why condonation of delay?
My lord, condonation of delay because the last appeal, which I thought that my erstwhile advocate had filed in 2008, my lord, that has not been filed. So the fresh
appeal, the statutory appeal was not at all filed?
No, my lord, it was not filed.
So where have you stated that in your application?
ক্রিমিনাল কেসটাতে এর বিরুদ্ধে হলো
এর বিরুদ্ধে হচ্ছে
হ্যাঁ
original application at page 120 21.
Yes, my lord, this was filed, your lordship.
Then why they are saying in paragraph 7, why you have said that
that is the earlier
that original or not an application filed your petition on that OA number, no such order was passed?
My lord, that was the earlier original application, your lordship.
Yes, that is page 121. 121 is the order on
yes,
that.
Yes, my lord. But the order was also never passed, your lordship. The original, neither the original application was filed nor any order was passed in the matter, my lord. So I had to prefer another original application in 2015, my lord.
Along with an application for condonation of delay.
My lord, an original application along with the application for condonation of delay.
Application
Page 124.
for এমএ
এমএটা ডিলেটে কোন
দিলেছে কিন্তু অ্যাপ্লিকেশনটা ওয়েটা
My lord,
ওয়েটা অ্যানেক্স
my lord, it starts from page number 25, your lordship.
25.
Yes. এবার
না ও তো প্রেয়ারটা হচ্ছে
ডিসমিশনটাকে চ্যালেঞ্জ করলো মানে দিলে
ও আচ্ছা ডিসমিসাল অর্ডার ওয়াজ চ্যালেঞ্জ সেই জন্য ডিলে কন্ডন করার জন্য অ্যাপ্লিকেশনটা কি ডকুমেন্ট ফোর্স করেছে
এই অর্ডারটা ট্রাইব্যুনালের অর্ডারটা So no statutory appeal has been filed by you.
Yes, my lord.
Even no original application was also filed before the learned tribunal.
No, my lord, I had filed an appeal against the dismissal order.
Huh?
My lord, I had preferred an appeal against the dismissal order, your lordship.
You preferred an appeal?
Yes, my lord.
But no original application was filed
My lord, the
by
original.
you. There is no such way which was registered as 301 of 2008.
No, my lord.
And hence register of the tribunal lodge an complaint with the jurisdictional PS based on which a criminal case was started against you and another person.
Yes, your lordship.
Now where is your application for condonation of delay? Page 1.
My lord, page number 124.
File.
99 to A number নয় 301 মিলছে না and the other is 301 of 2008.
Yes, my lord.
So which original application you filed?
My lord, as per my instruction, your lordship, both of the original applications, they were forged. My lord,
Both are forged.
Yes, my lord. My lord, the erstwhile advocate had forged the. They were not forged, my lord. Basically, the erstwhile advocate, had not filed the original application at all. I was aware that the application has been filed and order has been passed in 2014. When I took the order, when I received the order, I went to the factory, Your Lordship, to communicate the order. There, my lord, I was informed that no such application has been filed. So I went to the registrar of Central
What
Administrative
about
File.
the earlier one, OA 99, which you have stated in your application, page 126?
My lord, regarding that, I have to seek instruction, Your Lordship. I am not aware of the earlier one. Yes, my lord.
You challenged the same by preparing an original application in 2015. After almost 19 years.
8, my lord.
2015.
This
When
application,
dismissal order was passed.
My lord,
dismissal was
dismissal
96.
96. Ultimately, you challenged the order of dismissal by filing original application in 2015.
Yes, my lord.
15 ultimately.
Yes, Your
In the meantime, there is a story of manufacturing the document, order of the learned tribunal, such and such. Now you say whether it is sufficient cause. Time must probably 1 year. Section 21.
Yes, my lord.
Now whether this story or this incident of forging document, and you are also a party. In party judgment, you are also an accused person in criminal case.
No, my lord. In the criminal case.
You come most probably. Okay. Let's see.
My lord, at page number 18, Your Lordship.
Yes, in FIR, your name was there most probably. Osit Mondal and C. A. Guho, the learned advocate. Now in the charge sheet, only the learned advocate. No charge sheet has been submitted against you. Yes, you have been left out. I mean, no charge sheet has been submitted against you, only against the learned advocate.
Yes, Your Lordship.
Initially, FIR was lost against both of you and your learned advocate, but subsequently, only in the charge sheet, the advocate was cited as an accused person.
Yes, my lord.
This is the incident.
না এখানে আরেকটা গল্প আছে। Not your age, the age of the petition.
Yes, my lord. My lord, in 22, he was 53.
53 years. 4 বছর 57 বছর হয়ে গেছে।
Is it about 57 years? On which date you hand over the documents to your learned advocate, to that learned advocate, Mr. Go? Can you show us any?
10th July
15 last time. That advocate, Mr. Go, that apart, one appeal, petition of appeal was presented. The respondent says no such appeal was ever, copy of such appeal was ever received by the department.
But my instruction is, my lord, that I had preferred an appeal. And the documents regarding the appeal were given to the learned advocate.
How can we help you now? How can we help you, madam? A Mr. Rai who appears for railways?
Who
is there?
Yes, Mr. Bagh is there.
Yes, Mr. Bagh, you are there.
Railway.
Was any advocate there in railways appeared earlier?
Yes, my lord. Mr. Shatarup Banerjee.
Shatarup Banerjee. They are in the panel. Shatarup Banerjee.
My lord, it's not against the railways, your lordship.
It is against the defense.
Yes, my lord. Ministry of Defense, your lordship.
You are employed under whom?
Metal and Steel
Ordnance
Factory,
Factory.
Ishapur.
Oh. No, sorry, Mr. Bagh.
Your lordship, I'll inform the ordnance factory officers. It could be kept on Monday, and the council who is appearing.
What, madam, what can we do? Have never received any petition, any appeal petition from you. It
Yes,
is
my
true?
lord. My lord, it is their stand. Your
It
lordship.
is their stand. All along they took this stand. That they never received any petition of appeal from you.
Your lordship, on similar issues, certain orders were passed by our one of our coordinate bench regarding these matters.
This matter.
Same issue was there. Even contempt proceedings was initiated. What had happened, several petitions by the associations were filed before the Central Administrative Tribunal. However, parties were never served. So
that is not the. There was a departmental appeal. Don't say against the petitioner without being apprised of the fact. If we are taking so much trouble, we need your assistance, not complaints. Where is their reply to the original application? To this miscellaneous application, did they file any reply?
No, my lord, no reply has been.
Page 131 is reply to what? Yes, they have filed.
135 is the rejoinder, your lordship.
Where they have stated they have not, para 6, never submitted any appeal.
The applicant never submitted any appeal against the order dated such and such, nor submitted any representation before the appellate authority. But without application, he remained silent for 19 years, ultimately filed original application in 2015.
Without approaching the appellate.
Senior মিস করে দিলে সিনিয়রকে বলে যেত কেসটা প্রেস করতে সুযোগ করে প্রেস করতে এসেছে সিনিয়র কিছুই নেই খবর
What is your name?
Anushka Ghosh, your lordship.
Met with. But after the respondent, my lord, original applicant for the land tribe.
Yes.
My lord, with this matter, 8 analogous matters are there which have not been listed.
Don't make us afraid. Your first thing you're saying 8 matters involved.
Which have not been listed, my lord. Therefore, my lord, I humbly pray that all matters be tagged together and my lord be listed after 2 weeks.
Which matter is similar to that. So it has been tagged. It has not been tagged.
No, but there are other matters, my lord. It is true. But my lord, this matter could be, my lord, independently heard if your lordship permits.
No, there was an earlier order.
That is there, my lord. All these matters are filed together.
In all those, you are also appearing.
Yes.
So you give the
yes.
number গুলো আছে
number গুলো দেওয়াই আছে.
These are the
49, 50, 51.
Oh, all of them were disposed of by single judgment.
Yes.
তাহলে এই 5টা যেই ম্যাটার গুলো রেকুইজিশন করে নাও, করে যেদিন ফাইলটা এসে যাবে সেদিনকে লিস্টে তুলে দেবে।
Grateful.
You remind us after one, if not done.
Lordship.
Yes, next.
7 to 10, I am for the petitioner.
Yes.
But this is a matter, my lord, where, my lord, same issue is involved, respective common order is passed by the tribunal.
Yes.
Kindly take, my lord, item number 9.1. 10. No, 9 time prepare হয়েছে, তুমি 10 থেকে বলো, that's better. আমার ওয়ার্কআউটটা তো তখন মুশকিল।
এই দেবদুলাল, তোমায় বলেছিলাম না কন্টেন্টটাকে উপরে তুলি।
Recruitment board initiated a recruitment process for 8 posts. Kindly come to page 39 of the writ petition. This is the advertisement I have annexed, and page 43 are relevant. This is the procedure of recruitment. Page 39, the advertisement, and page 43, the procedure of recruitment is mentioned.
You can read this page.
Page 43, 7.01. Bottom. Recruitment process, it is mentioned.
Yes.
The candidate who has selected one of the regional language as the medium of the examination in item number 04 of information sheet of the application form will be supplied question booklet in English, Hindi, Urdu and regional language in RRB concerned. Those who have not opted regional language at medium examination will be supplied question booklet in English, Hindi, Urdu and only. Then 7.02.
We don't, I didn't follow. Those who have selected one regional
language as the medium of examination. In item number 01 of information sheet of the application
then
form,
he will be given question booklet in English, Hindi, Urdu,
and
the
regional language in RBB concerned.
And who has not applied, he will be only given English, Hindi and
Urdu.
Very good.
Then kindly 7.02, that is the procedure. The selection is made strictly as per the merit.
Yes.
There will be a common preliminary examination for all notified categories. Those who qualified for the main second stage examination will have the option to appear in the main second stage examination as detailed in paragraph number.
So what sense does those who qualify for
the preliminary examination?
Qualify for the main bracket second stage exams.
Second stage, because well, two stage.
Read the line, na?
Yes.
Those who qualify for the main second stage exam will have the option to appear in the
main second stage examination.
Then again, same.
Again.
In para 1.6a.
6a above.
মানেটা দাঁড়াবে
দুটোই তো একই কথা
there will be four main stage examinations on different Then what happened?
Then see, petitioner participated in the recruitment process. They succeeded in the preliminary examination. Thereafter, they are entitled to participate in the main written examination. They participated.
Second stage.
Second stage. They participated, but
the preliminary examination was written test.
Written test.
Huh?
Written test.
So there are two written
tests.
Oh, then qualified got into the second.
After preliminary qualify in the preliminary examination, they are entitled to participate in the main second stage written examination.
They
participated.
For one or all, or any of the,
or any of.
এইখানে হলো মানে four type of main second stage examination.
That is in respect of post. Kindly see different post because they advertise for 8 posts.
One person, one candidate, after qualifying the preliminary examination, he can appear for one, all, or any of the posts.
Yes. Then kindly come to page 54. After getting the result, your petitioner, my lord, came to know from the RTI information that he is not succeeded in the selection process. Kindly come to paragraph 2 once. This is the petitioner before your lordships, Mr. Kuntol Dotto, was supplied with a copy of the RTI information.
Yes.
Paragraph 2, it is mentioned that kindly paragraph 1, candidate bearing roll number such and such obtained 78.96 normalized marks in the second stage written examination for the post of NTPC graduate, category various of the SCN 3 of 2012. Paragraph 2, the cutoff marks for individual set red, green, yellow is not fixed. The OMR sheet of the candidate for 3 set questions paper were evaluated as per the key of the respective set of question booklet. After evaluation of the marks obtained by the candidate of 3 set question paper were normalized as per guideline of the railway board. After normalization, merit list is prepared on the basis of normalized marks. The community wise cutoff marks for different categories such and such is enclosed. Since the candidate bearing number such and such obtained 78.96 normalized marks in the second stage written examination.
Take us to the order impute.
Yes.
Take us to the order impute.
Now, kindly see.
What you are submitting, we don't understand.
What has happened? The railway board.
What is your grievance? You passed in the preliminary. You sat in the second stage. You were called for aptitude. Then what happened?
Well, they prepared the merit on the basis of normalized marks. But in terms of the notification of the recruitment, if the written test conducted in a single day, then normalization marks cannot be.
What do you mean by normalization?
Normalization, there is a procedure for normalization. Kindly see the page 168 once.
Then why you were rejected? Show us only that line.
Kindly see, this is the mention in the RTA information that they prepared the merit on the basis of normalized marks. If
Very
the
good.
marks is prepared on the basis of raw marks, that is the actual marks the petitioner got, then my lord, petitioner is entitled to get the appointment. That is my time.
Now show us normalized marks.
Kindly come to page 153 once. This is the Ministry of Railway Board notification regarding normalization of marks, 153.
Yes.
A copy of minutes of RRCB meeting referred to above is enclosed. It is clarified that wherever written examination is conducted is in more than one session or more than one day, then normalization of marks is required to be done. It is specifically mentioned if this is conducted in a different more than one session, more than one day, then normalization of marks is
So what is
required to be done.
normalization? What is normalization?
Normalization
What
168.
is normalization?
Page 168. There are calculation. Page 168.
Yes.
Since minutes of RBCB, the meeting held on 25th October 2000, then item number 1 agenda, permission sought by the chairman for holding written examination for selection of assistant station master category.
Where
2 days reading? Examination on.
Where you are reading?
The item number 1 agenda, top.
Yes.
Where, my lord, the examination was conducted on 2 days. Then normal.
This is of 2000.
That is
your
the
selection process was 2012.
12. They followed the circulars.
They followed this.
Yes, yes, yes. Now kindly see the bottom. At the bottom, there are procedure of calculation on the basis of normalization of marks.
Where do you
168 bottom.
Procedure
Suffix 1. This is the procedure in view of the decisions, in view of the difficult section by the chairman RRB Ajmer. It was decided that he may be allowed to hold examination on 2 days. It should be endeavor for RRB to ensure that both of the question paper are for the same standard. However, since the total equivalence of the 2 sets of question may not be possible, 2 sets of marks may be equalized by the followed method or standard of scores, which equalize the means of 2 sets of marks under consideration. It was also learned by RRB in discussion of the staff selection commissioner that the commission that they to follow the same method of equalization when examinations are distributed in more than one session. More than one session. The formula is given below. This is the formula of normalization. Now, what has happened in the recruitment process? Kindly come to page 171. Page 170. And kindly come to page 56. Page 56 first.
Wait.
Page 56. Kindly come. First of all, page 56. That is also the notification by the railway board. The examination, written examination
We
was
have adopted a procedure, formula. Suffix 1, suffix 2.
The written examination was held on 18th August 2013 on single day and same session. one session, 1 day. Paragraph 4, page 56, paragraph 4. Kindly see their instruction. In partial modification of the board letter at reference or above, this main second stage written examination of all NTPC graduate categories is planned on 18th August 2013 in one session shift only. We participated in the single day examination. My merit should be decided on my actual marks, not the normalization marks.
Written examination for all NTPC graduate
categories. That is the 8 post which they have advertised.
That will be held on a single day.
Single day, 18th August 2013.
That is pertaining to different subjects.
Pertaining to different subject, different post.
So the written examination, which
subject, but different post, but subject question paper same. Question paper same.
Then where they are getting your normalized mark?
Normalized.
Why they are taking
that is the violation.
No, they are saying that 2 examinations if held, question papers will be different. So they say that you set the question paper of the similar type, and the first examination marks and the next examination marks will be taken into account for normalization. This is
their condition.
Now your examination was held on a single date.
Single day. Their affidavit in the
Now
reply.
now what did the tribunal hold?
Yes, kindly see. Page 143 is the order impugned.
21st July 22.
21st July, yes, 141.
Then you appeared in the aptitude test.
Yes.
Appeared in the aptitude test.
Appeared in the aptitude test in respect of 2 posts. Assistant station master and there are another post. In 8 advertise in respect of 8 posts, advertisement was made, but aptitude test was done in respect of 2 posts. I kindly see relevant page is at page 142. Paragraph 3, Roman 3.
Allow us to go through it.
এই শতাব্দী ফ্রন্টারি
Yes, so what is the direction of the tribunal? Paragraph 7.
Paragraph 7. Hence, the order final merit candidates shall be prepared on the basis of their normalized score, mentioning therein raw score and aptitude score.
So normalize this when the written test and the aptitude test in your case was held on the same day. Written test and aptitude test were held on the same date.
Same day, then normalization not applicable.
Very good. It
Yes.
was same date. Now, what has been detected? Normalization would appear when there are two set of marks given, one in the written test and the other in the
aptitude test.
Now, what did the tribe? Why you are aggrieved by this?
Aggrieved because, my lord, it is ordered that a final merit list of candidates shall be prepared on the basis of their normalized score. That is not permissible.
The next line.
And mentioning therein the raw score and aptitude test score and number of vacancies. If the applicants have finally succeeded, then there are vacancies. They shall be duly adjusted against the available vacancies, or else a speaking order shall be issued and communicated to them within 2 months from enclosing the comparative assessment of candidates who have found place in the merit and select panel. Our case is that, my lord, preparation of the merit is not tenable in the eye of law, because, my lord, it is against the spirit of the notification. Its own notification dated 30th October 2007 and 1st July
30th October 2007 was not placed before the tribe.
1st July 2013 was placed. 1st July 2013. Kindly see page 144 once.
Where is that circular? 1st July 2013?
56. Page 56. And then kindly consider page 40.
I am not still being unable to understand this normalization.
Normalization, a specific procedure which varies the marks of the petitioner are all candidates. The calculation is given page 168. Method of calculation. And kindly consider page.
That the process of normalization would be adopted. It was not specified in the advertisement. Subsequently, they found that the number of the candidates are higher, and hence they held the examination on 2 days.
No, in our case, my lord, the examination was held on 1 day. That is my case. Page, kindly come to page 48 once. The advertised notice prior to written examination, page 48. It is specifically mentioned in paragraph number 2. Page 48, paragraph number 2. Paragraph number 2, the main second stage written examination, all NTPC graduate categories is scheduled to be held on 18th August 2013 in one session and 1 day.
One session, 1 day. I don't understand why 2 sessions will be held. If the post is same and there were 8 advertised posts, your examination was second stage examination was on 18th of August.
One single day we appeared.
Very good. Then the normalization appears when?
That is my case. Normalization not applicable in my case. Because there is a specific averment. Vacancies they are till date. 43 posts are remain vacancy in assistant station master post, and goods guards 41 vacancies there.
So your examination was held on a particular day.
Single day.
But in view of the number of candidates invited, that is 10 times of the post, they may not have completed the examination in one go. Or that maybe they have held a second stage exam.
But that affidavit has not said so. the affidavit by the railway
Kindly come
authority.
to internal page paragraph, internal page 3 of the order.
Order, yes, yes,
In the middle of it,
yes.
our attention
Our
is drawn
attention drawn
to para
paragraph.
A at page such and such of report.
There should be a second test
In
examination.
addition, there should be a second stage exam which will be conducted in a single session. Candidates numbering 10 times the number of vacancies shall be called for the second stage examination in order of the merit, common merit list of the first 2 sessions of the examinations. So as the candidates were 10 times the number of vacancies, they held 2 examinations. Your examination was in 1 session. They held 2 examinations for say 41 examination, another 40 in the second session. Now, as the first exam was held in first session, to eradicate the eventuality of paper leakage, they are making a different question.
Well, there were
Yes,
yes.
as we are understanding,
Yes,
they
yes.
are making a different question paper so that there is no leakage. So you get in the first session, suppose you have got 50 marks.
Yes.
But in the second session, what
But
procedure
in
you have
one day, one session, it was conducted.
Yes, Lordship.
My instruction is that.
Examinations were held not by giving 6 sets of papers.
Pardon?
6 sets of papers are there. 6 sets.
Achha.
Milord, now, Milord, the procedure, normalization procedure is this, Milord, the collection of raw data into an unified data. What they are, suppose, Milord, my question paper is different, his question paper is different, and somebody's question paper is different. So, Milord, 6 set of question papers were given to the examinees. Now, Milord, ultimately, Milord, all raw data was collected and that was put in an unified manner, and that was called, Milord, normalization. So that, Milord,
6 sets of question papers given for what?
6 total, Milord, 6 examinations are conducted.
6 second stage examination was conducted.
And 6 set of papers, 6 sets of papers are there.
But was their examination was held in the first session?
Yes. In the second session, Milord, total 6 sets of, Milord, examination papers are there. And 6 examinations are conducted. Raw material, raw data.
Very good. 6 examinations. Suppose you and myself appeared in the first stage, and my brother appeared in the second stage. But it is not a case that I am being asked to appear in another examination.
No.
So why this normalization done?
No, as because, Milord, number of, Milord, examinees, sir, Milord, huge number of examinees. That's why, Milord, they have conducted, Milord, this examination in different, by giving different sets of papers. This is the procedure, Milord, followed in
only 17,000.
If there is a
whatever it may procedure, we are wanting to justification of the reason.
Milord, justification is this, Milord, if your Lordship, Milord, kindly takes, Milord, item number 10 once. Item number 10, Milord.
What you are showing?
Well, I'm just placing, Milord, what is this case. Milord, it is saying, Milord.
Tell him which paper he is in this item number 10. That paper is in which paper?
In this item.
Yes.
Reply.
354,
354.
That is the reply filed by the respondent.
Submit one thing, Milord. In terms of the order passed by the learned tribunal, Milord, the department has already passed an order.
Passed an order.
Yes. But kindly have a look at page 158 of.
An order, but there are vacancy, there is a direction. If the
They
vacancy is
should
there,
challenge this order.
then petitioner can be accommodated. But the preparation, when the tribunal found it that it should be done on the basis of normalization marks, and the matter referred to the authority. Authority cannot.
Already passed an order. They should have challenged this order.
Where is the order?
Only
Page 158. Well, kindly have a look. Take
Where
this
is that order in this petition?
petition item number 9.
Nine.
Yes, yes, yes.
Order 23rd of September.
Yes, yes, yes.
এতক্ষণ বলে টলে তো that should have been your first submission.
Kindly come to page
Sir, Mr.
186.
You were practicing for so long.
Page 186.
Tell your weakest point first. That is what we learned. That tell the court which is your most weak point. Then develop your argument. Otherwise, the court gets irritated. After 1 hour of submission, if some court comes to know that an order has been taken, then the first argument would be whether you are required to challenge the same by a fresh application or we should consider it. This should be the mode of argument. এরকম করলে হবে না। I'm
Challenge in
But the they page 186. Kindly see the order once. Kindly see the order. If the tribunal stated that, my lord, the marks decided the issue, already affirmed the preparation of merit list on by
question, if this one is dismissed, then at paragraph 7 attains finally. Then even if I challenge that order, that will be futile. Because tribunal said that it will determine on the basis of
normalization.
That is your argument.
Yes. Because, my lord, I already read the notifications of the railway board itself. That is done 6 set of questions that is not into consideration. Consideration was that single day, single session. The written examination was conducted single day, single session.
But the advertisement provided multiple second stage examinations.
Multiple in our post.
Kindly
come to advertisement once.
Kindly come to 1.06.
Yes, yes, yes. Page 43.
There has been 4 main stage examination of different issues. Why you are saying 6 question papers? There were 4 sheets of 4 sheets.
My reply says not six sets of papers. Not
but the written examination done in 1 day and 1 session.
It
Then,
says-
my lord, the railway board notification will apply.
But they have held multiple examinations and they have normalized this.
Multiple examination on single day. Kindly see the notification dated 1st July 2013 once.
Multiple examination on single day.
Single day.
You faced one question paper, I faced another. So to eradicate the differences, They are adopting the procedure of normalization.
But the notice says otherwise, says one single session, 1 day.
That is page.
Page, kindly see page 153. Six set of question not relevant. 153. If the actual marks is provided, then petitioner will get the chance for appointment.
Not that normalization was applied, not applied to everybody.
But due to application of normalization of marks, the marks of the petitioners is reduced.
Yes, but that has reduced in respect of other candidates maybe also. They have used the normalization.
But if the actual marks is provided, then why not petitioner will get the chance. There is a clear case in the paragraph 10 also.
Paragraph 10 of?
Item number 10. Item number 10, the petitioner stated that if the actual marks is provided, kindly see paragraph page 6, item number 10. Item number 10, it is stated that the petitioner states that the raw marks of the petitioner in the second stage examination was 74.33, and after normalization, his normalized marks became 77.87. Page 6, item number 10.
9 you are arguing.
9 minor.
Where is 9? Where you have stated?
9 minor, it is not mentioned. It is mentioned in item number 10, paragraph page 6. How it's differ when the normalization is applicable for preparation of the panel. Page 6, paragraph 9.
Raw marks increased. Raw marks were 74.33. And after normalization, it increased.
But his aptitude test score for 250 feet, but he was not placed in the panel, first panel. But Sri Manoj Das, who secured raw marks 72.67 in the
after normalization, your score went up.
But what is the effect? Kindly see. In the second stage of examination, and the secured 254 of the aptitude test was placed in final select list, serial number 684.
Now, show us what is the wrong tribunal order. Which paragraph you want us to
kindly see. Page 143. Page 143, last paragraph.
Paragraph number?
Paragraph number.
Paragraph number not mentioned either. No paragraph number is mentioned. Bottom, page 143. Or internal page 3. Last paragraph. Further, RB one the number 116 of 2010 as relied upon by the respondent would have no manner of application in the fact and circumstances of the present case, and is does not support and provide any normalization where the examination is held in one session, and it does not speak about the method or normalization. So far, the circular dated 1st July 2013 is concerned, it has got nothing to do with the method of normalization. 1st July 2013, which is
internal page
3 and 4. It is mentioned 3, last paragraph. Internal page 3. Further that.
Yes.
RBE number 116 of 2010 as relied upon by the respondent would have no manner of application in the facts and circumstances of the present case, as it does not support and or provide for normalization where examination is held in one session, and it does not speak.
That circular is
circular to 2010 circular 170.
Page 116. RB 116 circular is why?
170, page 170.
170.
Yes.
And when the circular showed that it has to be in one session?
153. 153.
Whether
Kindly
it
see
is
the observation by the tribunal.
No, the RB number 116 of 2010.
Again, 170 page.
178 number.
Kindly see the rights and RB 116.
Oh, RB 6. Yeah. What is the now? Relevant portion.
Yes. And kindly see the tribunal's observation that for circular number dated 1st July 2013, which is annexed in page 153.
3.10.
It has got nothing to do with the method of normalization, but it is mentioned normalization. 1st July 2013.
Nothing, because your was held in one session.
Absolutely. If one session, then normalization will not apply. If different session, then normalization apply. This board notification says that. Page 153. One day, one session, then normalization is not applicable. But in the different day, different session, then it will apply normalization. But they prepared the merit on the basis of normalization marks. Now, my lord, the candidate who got lesser marks, they got appointment on the basis of actual marks. I'm not raw marks. That is the difficulty, and that is my challenge. They already ignored their. Yes. As per circular paragraph 1.06 of main notification, annexure A1 was modified. And this is the circular. This is the circular of paragraph 106. This is the advertisement.
106.
Page 41.
Page 41. এটা কোর্ট স্টেজে হবে এইটা
Page 41.
There shall be 4 main stage examination on different days and shift for category groupings. Yes, as per the circular para number 1.06 of main paid notification at annexure A1 was modified, and the supports the case of the applicant as the second stage examination was held in one session. So the question of challenging the circulars as well as the revised notes was uncalled for. Learned counsel were heard and information obtained by RTI read as under. That has already been, I have already, the candidate bearing roll number such and such obtained 77.87 as the normalized marks.
Now come to the next paragraph.
Next paragraph, paragraph 6. Normalization is an accepted procedure applied to all without discrimination. The applicant has challenged the manner in which the score in aptitude test is prepared.
Why does the tribunal say this? Applicant has challenged the manner in which scored. Now it is a
different. We challenge the procedure of normalization. We attach the OA application.
Then next line.
Unless it is evident from above that he had duly cleared aptitude test and his final merit list was prepared. Hence, he cannot bear to a grudge against the such procedure. But he can definitely grumble if the, despite availability of vacancies on the basis of imaginary cutoff marks, he is ousted from the final merit list. Hence, it is ordered that a final merit list of the candidate shall be prepared on the basis of normalized scores, mentioning therein the raw score and aptitude test, the core score the number of vacancies. If the applicant have finally succeeded and there are vacancies, they shall be duly adjusted against the available vacancy, or else a speaking order shall be issued and communicated to them within 2 months, enclosing the comparative assessment of the candidatures who have found place in the merit list and select panel.
Now kindly come in order. Their order means they pass.
Yes, speaking order. Yes.
From page paragraph
Paragraph 2.
3.
3. Since in the aforesaid order, the Honorable Tribunal has been pleased to direct the preparation of final merit, mentioning there in the raw score and aptitude test score. And since aptitude test was done for the purpose of assistant station master and traffic assistant only pursuant to CN number 3 of 2012, in compliance with the said solemn order of the Honorable Tribunal, the final merit list for the post of assistant station master category 7 and traffic assistant category 8 pursuant to CN number 3 of 2012 has been prepared afresh.
You are coming within these two categories.
No, we applied for the 8 categories, 8 posts.
Now for which category?
The
Category
8. Category assistant station master and traffic assistant and goods guards.
The cases aptitude test was
held.
Who appeared in those?
Yes. And also in goods guards also. We appeared on both 8 for the post of for 8 post. All posts we appeared.
Then how can their case be considered along with yours? Because in their district there was
No aptitude test. In terms of the advertisement, in respect of 2 posts only aptitude test was held.
Continue.
The final scores were calculated as per item number 7.02 CN of 03 of 2012, that is from the candidate qualifying in the aptitude test, with 70% weightage being given to the marks obtained in the main second stage examination and 30% weightage being given to the marks obtained in the aptitude test. Since qualifying in the aptitude test is a precondition for the selection to the post of assistant station master category 7 and traffic assistant category 8 candidate found not suitable in aptitude test has been excluded. A printout of the said final merit list is annexed here too. Your name is not featuring in the said merit list. The details of your score furnished below. That is the name of your petitioner, date of birth, details, and raw score in the second stage written examination 76.33. And raw score per 120, that is 78.96, and normalized scores in second stage 78.96, and normalized score as per 165.8. And the marks of the aptitude test is mentioned there. Since you were not found suitable in aptitude test, there was no question. Yes.
So you made normalization or no normalization is.
But in respect of goods guards, I am.
That you did not find, you were not suitable in the aptitude test.
Yes, admittedly. But in the goods guards, there are vacancy where aptitude test.
Raw score in second stage written examination is 76.33. Raw score per 102 is 78.96.
Raw score per 120 is?
120 এর উপর 120 তে কত? Normalized score in second stage such and such, and normalized scores are so. So how it has diminished? How you have been prejudiced?
Prejudice, my lord, in respect of other post, my lord, I am entitled. Yes.
Word score was not diminished.
No.
By adopting the procedure of normalization, you have got
more marks. It is appearing.
But normalization should not be done. It should be decided.
You have to show your prejudice also.
Prejudice, my lord, in paragraph number 10, I mentioned that in respect of normalization marks, the others are given appointment. Who has lesser marks than?
Then how many persons are here before us?
4%.
Now all of them were in that aptitude test category.
No. Only one. This person.
Those who were not in the aptitude case category, how were they examined?
Examined because, my lord, up to the stage of final written examination, there was no aptitude test in terms of the advertisement. There is specifically mentioned there. In respect of
Which item is without aptitude?
item number 7, 8, and 10.
7, 8, and 10. What reason order has been passed there?
Similar. So, just 158, item number 10.
But 10.
Item number 10.
Page 158.
But the speaking order did not mention that we are entitled to get appointment in other posts, other 6 posts, goods guards and assistant station master. There are
Page 159 now. There are 4.
yes, your category in his
after aptitude.
After aptitude test.
Then aptitude was done.
Done in the item number 10 also. Yes.
I am asking where the reason ordering cases were no.
Yes, yes. Item number 7 টা দে 7 টা দে ये তাড়াতাড়ি আমার
There are 2 questions. You satisfy on 2 questions. The process of normalization was adopted without discrimination. To all, it was applied. To all candidates.
It is
not
admitted
that it was applied to one set of candidates, it was not applied to another set of candidates. Applied to all, first. Secondly, had this process been not applied, you would have been appointed.
Yes. Well, the process of
appearing to us subject to correction. For applying this normalization, you have got more marks.
But still did not come in. So your actual prejudice is not there.
No.
Now you are saying that no. That's how in my case. You see, due to normalization, there are some cases actually got raw score was less than yours.
Yes.
He has got
appointment. Because, my lord, the application for normalization of marks is illegal against the spirit of the own notification, railway board. That cannot be done. Because, my lord, there is a specific instruction that
yes, what is your case?
And there are vacancy also.
My case, my lord, the normalization has been done, my lord, as because, my lord, you also knows.
Yes, in fact.
In one set of paper, there may be a tough question paper.
Set of question paper.
My lord, kindly take, my lord, my reply. Item number 10, my lord.
You have item 10.
If it is in opposition,
No.
Used before the tribunal.
Tribunal. Page 54, my lord.
Page 54, my lord.
Item number 3. Amit Ghosh.
Yes.
Yes.
Well, kindly tax page 59. What I have written.
Page 59. Any WBC earlier before?
Yes.
This what has happened in the year 2014 after publication of the result with not several. This is second round litigation. So first round litigation we approach before the tribunal together. Subsequently, the Honorable High Court give a direction upon the petitioner to file respective application before the tribunal. Subsequently, in 2018, we filed respective application. That is the original application.
Tell us that
the first order is at page 49.
That was passed in second round of
yes.
litigation.
Second round.
Kindly see page 49 first. This is the first order passed in WBCT number 42 of 2018. May I just place it? this writ petition is directed against a final order dated May 21, 2018, passed by the Central Administrative Tribunal, Kolkata bench, in OA number such and such, by virtue of the order impugned to the writ petition, the original application was dismissed. Having heard the Learned Counsel appearing for the respective parties, as also after considering the facts and circumstances of the case, we find that the 10 participants in the selection process for appointment of 10 different categories employees on the basis of the centralized employment notice number such and such, and they were all unsuccessful in the selection process mentioned. The tribunal, on the basis of the following grounds, were advanced before the learned tribunal on behalf of the petitioners, which were set out at below. The selection process is non-transparent and non-judicious. Although there were stipulated conditions of 3% handicap quota, the handicapped applicants were not offered the appointments against the side post, despite having all this. Roman 4. Roman 4A. The normalization of marks, which according to the Learned Counsel of the applicant is totally inapplicable, given that the such principles of the normalizations was never reflected in the advertisement. Now, fifth category, then this HON'BLE court will not kindly see page 50 last. While considering the aforesaid grievances of the prisoner, some of the petitioners were aggrieved for non-consideration of their claim under the 3% quota earmarked for the physically challenged persons. The ground agitated by some other applicants was non-consideration of the question of giving additional weightage of their additional qualifications. Apart from two common grounds of normalization of marks and conducting the fifth category of aptitude test, incorporating the material beyond syllabus. Considering the above grounds, we find the petitioners were not similarly circumstanced for challenging the selection process in questions on the same or identical grounds, save and except two grounds as mentioned here above. The original application should have been dismissed in limine on the ground that alone for non-joinder of cause of actions and clubbing the cause of actions in one applications. At this stage, on the pair of the Suggestions Learned Counsel appearing for the on behalf of the petitioners to grant liberty to the prisoner to approach the Learned Tribunal separately by agitating their individual grievances. It will not be out of context to observe the none appears on behalf of the respondent number 1 before us in spite of the service of the writ applications upon the above respondent. The respondent number 1 is authority appointing the selection process. Be that it may be, in view of that, we pause and set aside the impugned order of the petition and dismiss the original applications on the aforesaid ground alone by granting liberty to the prisoner to agitate. So thereafter they filed. Now, on the basis of that, this application was filed, and the tribunal was had been pleased to pass an order on 21st of July 2022. Now, 21st of July, tribunal passed an order. On the basis of the tribunal's order, department passed an order, page 158. That is on 23rd of September 2022. So, tribunal order is yes. The tribunal order is 23rd September 2022.
And when was the order?
Tribunal passed an order on 21st of July 2022.
Acha, what was the order which was challenged in page 49?
Page 40.
Now you said page 49?
Yes. Well, the order.
Where is the order of the tribunal?
The order of the order of the tribunal was not there. That is not there. Only one thing, may I just point out, tribunal order is 21st of July 2022. In terms of the tribunal's order, department passed an order 23rd of September 2022. And this writ petition was filed. Kindly have a look when this writ petition was filed. In the month of March 2023. 23. So, they have availed the opportunity of the order passed by the Learned Tribunal. Thereafter, participated in the proceedings. The department passed an order on 23rd of September 2022. And after that, they moved this writ petition challenging the order of the tribunal. My submission before your lawsuit would be in view of L. Chandrakumar, they should approach the tribunal by challenging the order dated 23rd of September 2022.
No, but if we give them that liberty, normalization issue will be down.
Normalization issue is
We will keep open the issue of normalization.
Yes, so far as this order is concerned, this is also effect of normalization. Let that be decided by the tribunal. Ultimately, in view of L. Chandrakumar, he has to, the court of first instance must be the tribunal. He has to challenge this order.
We are saying tribunal has held normalization was okay.
Tribunal has held normalization over, okay, my learned friends kind.
Of that observation, you passed an order.
Yes.
What the tribunal said, normalization is all right, but as there are sufficient remaining vacancies, now must be obtained on the basis of normalization, and then if you find there are vacancies after the last candidate appointment, you give them appointment. This was the tribunal.
Yes. Now, so far as normalization is concerned, my lord,
Because recent order does not discuss this issue as to whether there are vacant seats or not.
so, my lord, reason order, my lord, whatever it may be, my lord, reason order passed by the passed by the authority, but it has to be challenged before the my lord, tribunal.
এইটাকে যদি ওড়ানো এইটাকে যদি ইয়ে হয় তাহলে তো অর্ডারটা আবার ইম্প্যাক্ট
My lord, kindly see, my lord, my reason order, my lord, page.
Now they are aggrieved with this observation that normalization is a accepted procedure applied to all without discrimination and hence direction to prepare final merit list on the basis of their normalized score, they are aggrieved by.
Now, so far as
Aggrieved by this order.
so far as normalization is concerned, my lord, let us.
Application of normalization procedure, whether correct or not, is a question to be decided.
That has been decided by the tribunal.
That decision is under challenge.
That decision is, well, kindly consider one thing. Person will is basically a fence sitter. The person will who was waiting. Absolutely.
Since 2014, we are
kindly consider, well, the order was passed. Order was passed by the tribunal on 21st of July 2022. Department passed around on 23rd.
Answer my brother's query.
Well, so far as well, normalization part is concerned, well, may just place 3 pages of my reply. Well, kindly turn page 59. No, 59, only 59. Of item number 10.
You will read from two different petitions. You will read from item number 9, you will read from item number 10. Yes.
I'm sorry, Milad. Well, page 59, Milad, kindly take Milad Roman 7. It's, I'm just, what was the pleading before the tribunal? I'm just pointing out. On the basis of the first stage examination, the present applicant was shortlisted for the second stage written examination and subsequently was also shortlisted for aptitude test. Finally, on the basis of the performance, the applicant could not be considered for final selection. It is submitted that the second stage written examination was held in two different shifts, and each shift there were different sets of question papers. This was as per Railway Board Circular number RB 1162010. Thus, there are 6.
You tell the page number.
Page number. Page number.
Page
number 1st July 2013 circular.
No.
That is 2010.
170. Page 170, item number 9.
Now,
3.10 তে একটা বলা আছে নাকি 3.10 only this এটাতে কি হচ্ছে process of normalization.
Normalization is not mentioned in the circular.
Where this circular? You show where?
Circular is at page, which is 153. 153.
153.
Railway Board Circular 116/2010. That is at page
170.
153 বলছে 153 তে নেই তো
Nothing is mentioned regarding normalization.
সেটা ওরা বলছে
examination was held in 3 sheets.
It is stated, my lord,
Two shifts.
two shifts, 3 sets of paper, 2 shifts, my lord, total 6 question papers were there. My lord, you also knows, my lord, in such a case, my lord, when the some
এইটা যে বলছি the circular. It is a circular dated such as circular is system for transportation, storage and distribution of the question paper.
That is not applicable. That is my case also.
Can he prescribe the mode how the number will be awarded? How the question paper will be distributed, stored and transported.
normalization, my lord, this normalization is a process, my lord. 116
3.1 কটা সেট দেয়া হবে এটা কিন্তু ইয়ে নয় টু শিট 3 মোর
held in more than one session.
Yes. One day more.
Finish it off. What is your stand?
Well, my stand will kindly takes me page 60. It says, Lord, this thus there were 6 different sets of question papers. There is every possibility that the difficulty level of questions for different sets are also different. To prepare a common merit list of the candidates appearing in different sets of question papers, the only possible procedure is adoption of normalization, which means adjusting values measured on different scales to a normal common scale. In this context, the policy has been framed by the Railway Board and same has been followed by the Railway Recruitment Board. The normalization formula was adopted by the Railway Board and same was circulated by Railway Board's letter number dated 30th of October 2007.
30th October 2007.
30th October 2007.
30th
October 2007.
2007 153, my lord.
153.
153.
এই যে
এটা কত সব ইয়ে হয়ে যায় এখন সেই পিটিশনটা সেই অমিত মন্ডল কি এটা এখানে তো
Now, my lord, much before the publication of the present employment notice and the normalization of the score is obviously a prevalent and existing policy of the railway and cannot be termed as a new policy adopted in the instant recruitment only. Moreover, normalization is a generalized policy and is applicable to all the candidates appearing in the recruitment process. It is not an instance of arbitrary and malfide exercise of power, and there is no question of any discrimination. In this context, the observation of the Supreme Court, Sunil Kumar was quoted. Now, my lord, kindly have a look, my lord, page, my lord, 62, or rather, my lord, page 63. It's may I just place, my lord, from page 62, my lord, last paragraph. The scores obtained by candidate in each test are converted into T-score as per the Railway Board's order.
Sir, that is your RTI.
Yes, RTI reply. Now, my lord, it says, my lord, candidate who failed to obtain qualifying marks, that is T score 42 in any test in deferred is not suitable in the result sheet and no marks was assigned to them. It is further submitted that cut-off marks for the aptitude test is not fixed separately. After completion of the aptitude test, final merit list of the safety categories are prepared by adding the marks obtained by the candidate in the written examination and aptitude test. Ratio of the marks obtained in the written examination and aptitude test is 70-30. Thus, the normalized marks obtained by a candidate in the written examination, here the second examination is converted out of 70 and total marks obtained in the aptitude test is converted out of 30. Thus, the final marks are made out of 100. Now, this employment notification 7.2 was referred. Now, next page, kindly see, page 64.
No, next clause.
Yes.
Community-wise cut-off marks in the first stage written in the cut-off marks in second stage for calling for candidate.
Test and the final wise.
Is annexed here with this annexed here. This was not there in your advertisement. Your advertisement did not say about any normal.
Yes. Advertisement says
annexed here R5.
annexes are not there.
And kindly, may I 1 minute. In the affidavit opposition, in paragraph number 16, they have stated that it was conducted in one session, but 3 different sets of questions. One session, one single day. They have stated that.
You cannot deny that there was your examination was in one session. There is no dispute. But there were other sessions of exam. We have extensively heard.
Get.
But information as to whether your posts have been filled up or
my recruitment process completed.
that we know.
Number one, number two, there is no question of filling of any post in terms of that notice. No
Vacancy is there or not? That is
There were additional meetings.
Yes.
Take information.
Yes, I oblige, my lord.
Sorry, my lord. Again, sorry to trouble your lordships again. That assignment, my lord, your lordship has not got the time, my lord. That assignment which was pending, I had mentioned earlier. That my lord justice,
Here to meet secretary.
my lord, they are meeting every day. But I was told that your lordship was tied up, so I was humbly requesting kindly spare.
What's the number? What is your assignment letter? Where is your assignment letter?
Well, I'll give the number of the cost title of the procedure. Yes, we've given it to the OSD. The office copy will file it just now, my lord. They don't have it. They have it on the iPad. That is the problem.
So you make a hard copy and hand over to my court officer.
I apologize for troubling your lordship again and again. I'm sorry. Grateful.
Oblige.
उनको दीजिए
I don't appeal with the cyber computer.
When was the order?
What is the 32 months?
When did you apply for surgery?
On 8th July. I just only I'm praying.
What is the article?
I just want to just file it first, so I
Get the certified copy and file.
I applied. I will apply.
Then file.
It
Will appear
takes
on
some
the-
time, man.
Yes. All
Milord, item number 11 and 12 are analogous.
11 and 12 are
12,
Milord, in item number 11, it is by the union's writ petition. I succeeded before the learned tribunal and they agreed and they filed. Now, the next item there, I also questioned, like the tribunal, it's a pay fixation. Tribunal granted, Union of India granted X. Now, tribunal granted X plus 1, which they lost. Now, I said that it should be X plus 2. So,
therefore, for some time I would be this side, and thereafter I shall go to that side.
Well, I should no. May I say very candidly? May I say this? As such, there is no urgency. Only thing is that the earlier division bench, presided over by the Honorable Justice Sujoy Paul, in an similar matter, having found that there are
Prior that time, the matter was heard by Justice Madhuresh Prasad. Yes.
I'm not on merit at all. Only I'm saying that
because it will take some time.
Yes.
If Lordship goes into the merit of it, it will take time. But as far as I am concerned, I am relying on the Kerala High Court up to Supreme Court twice. And that was said before the other Honorable Division Bench. The only difference is there the council was asked that you take a fair call on that, and there the council appearing for the Union of India said they are similarly situated. So whatever the Kerala High Court they have granted relief, they are also entitled. Its organization is fundamentally
Another matter.
Other matter.
Because Union of India has several councils.
But these two matters were heard by Justice Madhuresh Prasad.
That was on motion stage, nothing
But
to, not hard, not hard. It is
mostly heard, but not in detail.
Not.
Keep it on 19th August.
Yes.
19th August.
May I? No, not at all. Not. This is not called hearing.
Not in detail.
Not. My lord, may I say this?
But
Otherwise, I would have. This is not. Well, we should not embarrass even the other court also. It is. There was a. Well, if even.
Let this be heard by your lordships.
That's
There may be conflict of opinion.
There is there conflict of opinion.
One thing is hearing by two different benches.
No. Conflict will come if there is an opinion. It was not hard at all. It was by the Honorable Justice Sujoy Paul.
No specific order was passed.
The matter which
in the meantime, determination was changed and matter is changed.
Well, I will come with a very short note. I made a rough note also, so that I will.
Well, I have also prepared, my lord.
So we can.
Yes.
That would be easier.
Yes.
Because if Lordship feels that there is no requirement of again freshly. Well, with short note from both sides, I don't think it would take more than 1 hour.
1 hour for each of us.
Other matter pending
Justice Prasad had it on many days.
But this was not hearing, because one day I said that originally it was only Union of India's writ petition. Once I appeared, I said that after conference, I suggested my learned advocate in record that you should also file a writ petition. Though you were successful, but in Kerala, in other parts of these states, already X+2 has been given to everyone. And thereafter that was fine.
Milord, principally this matter has already been decided by the Honorable Supreme Court.
That
19th August. In the meantime, Milord, we shall exchange the
yes, we'll do that. It would be, my lord, it will shorten the time a lot.
I have prepared, Milord, compiling both the matters.
Yes.
Yes, next.
May it please your lordships.
A picture for Union of India.
That if one order is passed so far 19th is concerned, that may help us.
I really cannot order. Is ready, Mr. Samanto?
Yes,
Well, we are not
no,
being served.
I have not filed a reply. Reply is not necessary, Milord. Your lordship can, on the basis, because reply was filed
before the time.
And same thing has been repeated. Nothing new. Your lordship comes to page 4. To shorten the issue, it is arising out of a departmental proceeding, which was challenged before the learned tribunal. My lord, I'll be taking these points at page 4, my lord.
Page 4 of the order.
Petition, my lord. Petition. I'll shorten the issue, my lord. That's why I just. These are the short points, my lord. Now, my lord, lordship kindly comes to the impugned order passed by the learned tribunal. It's a proceeding of 2018 before the learned tribunal, and the order was passed on 22/6/2025, rejecting my application. OA.
Yes.
Should I place the order, or your lordship will read it, my lord? My lord.
Just this for
ওই পাঠটা দাও।
157.
রাজু এটা ভাগ করে সম্পূর্ণ দৃষ্টি পুরো দৃষ্টি
কিছু
থেকে করছি
Lordship will be pleased to take up page 93 once. When we first challenged the proceeding in an earlier way, page 93, my Lord. Order passed by the learned tribunal. My Lord, in the main petition, my Lord. In the main petition. Page 93, my Lord.
Yes.
It's an order passed, my Lord, by the learned tribunal on 17/2/2014. In the earlier way which we filed, my Lord.
That was set aside.
No, this was not set aside, my Lord. Ultimately, the tribunal held that you file a statutory appeal. Because in the meantime, but Lord, I am showing your Lordship only one thing, Lord. Lordship kindly comes to page 94, paragraph 3.
First, tell us one thing. Why do they say in the charge that this 30th February 62 appears to be absurd? Why do they say that?
It is absurd. I mean, your Lordship wants to say.
February, my Lord. In the month of February, can't be.
Oh,
30th.
yes. 28th February.
28 days.
Either 20.
Maximum 29, it can be.
Can't be 30th.
Yes, tell us.
Now, my Lord, kindly comes to page 94, paragraph 3. In reply to the charge sheet, the applicant has categorically denied having submitted the school leaving certificate, wherein the recorded date of birth is 30/2/1962, which was issued on 3/2/1979. Lord, one thing is very important. At that time, he was boy service, less than 18 years old. His father had done everything that has been admitted in the reply also, if opposition. I'm coming to that, Lord. He was even denied having read in the said institution and have submitted that he was a student of Rajvanshi Devi Ucha Vidya Mandir at Thepa, Sipuan, Bihar, in support whereof he has produced a transfer certificate dated 3/2/1979 from the said institution, where his date of birth is recorded as 20/2/1962. The inquiry officer found that the allegations leveled by Article 1 is established and the applicant was guilty of submission of fake certificate and misguiding the railway administration. He has come to a conclusion that transfer certificate of the applicant with service record showing as 30/2/1962 as fake and the date of birth is absurd, and the transfer certificate issued by the principal is also not genuine. While coming to the said conclusion, the inquiry officer has not sent for verification of the certificate issued on 3/2/1979 by Rajvanshi Devi Ucha Vidya Mandir at Thepa, Sipuan to the school board. My Lord, this certificate which I ultimately gave, that was not sent. That is in our defense also before in the departmental proceeding. And my Lord, this was after looking at the records. The court called.
That is because you furnished that Dhanbad certificate by signing the attestation to be genuine and true.
My Lord, what happened, I'll tell your Lordship. I took instructions. At that time, he was 18 years. His father had done everything. He just put his signature. He told me this. That is a fact. That is the main problem. And my Lord, the funny thing is,
did not know in which school his son was studying.
My Lord, because his father died in 2000. And the proceeding started in 2012. After, my Lord, 32 years. The question is, my Lord, because he was reinstated by an order of.
That is another point. You first satisfy us on this point.
My Lord, Lordship will look at this. So this document which he ultimately gave, that was never inquired into.
That is Sian.
Yes, Thepa C1. Yes, it was never looked into.
But Mr. Samanto, the first thing arrived at a finality. Attestation, you produced the certificate. Upon inquiry, it was now found. You can take the point of 32 years, we'll hear you. But after inquiry, it was found that Nandolal certificate is not genuine.
My Lord, problem is, my Lord.
This is one thing. To that, your argument is that I am not to be blamed because
That's right.
father gave those details.
That's right.
But Mr. Samanto, father must be knowing now which school your son is studying.
Problem is, my lord, if he died in 2000, proceeding starts after so long in 2012.
That will be hearing your argument on the issue of delay.
Delay.
That is there. But my lord, the question is, my lord, your lordship looks
Our
at it.
question to this issue, your answer is that I am not responsible. because
I was
my father
18.
has given.
I was boy service, my lord. I was 18. I had no idea. If I put a signature, my lord, at 18. And my lord, the main thing is that this was started when? Lordship will consider this aspect of the matter. It was started when? It was started because I got an order from the tribunal of
That
reinstatement.
we will consider.
Now, my lord, kindly comes, looks at this, my lord.
Prothom point
My lord, lordship kindly comes to paragraph 4.
Where on scrutiny, it was found that your certificate produced by you in support of your date of birth is showing an absurd date. 30th February
My lord.
in any calendar year, in English calendar year, does not count.
Does not, yes.
So either the recording of date of birth is wrong,
or the document itself is
certificate
bad.
itself is fake. Now you took the plea that I never read in Nandolal institution.
And I gave a document.
And you made a assertion. What assertion? I read in another school, Rajbongshi school. So burden of proof come up from you.
My lord, that was proved. That was proved. Yes, my lord.
You submitted a certificate, but in support of such certificate, the head of the institution could not produce anything.
No, my lord, because
so it would be deemed to your failure.
My lord, records were burnt away. That has been recorded. I will show you, lordship. Kindly
Now
come.
it is the year.
Kindly comes to that. My lord, kindly don't place everything. My lord, I'll tell you. My lord, lordship kindly comes to paragraph 4. My lord. We also find the allegations leveled against the applicant is with regard to an incident which has occurred 33 years back. The applicant alleges that past case has been raked up to quench a personal vendetta against the applicant since he had succeeded in being reinstated from setting aside of a removal from service by this tribunal's order dated so and so. It is also alleged that the authorities have not leveled any allegations that the applicant has in fact submitted the certificate where the date of birth is mentioned as 30/2/1962 in order to secure employment to earn an unlawful gain. We also find from the records, lordship will look at this, that the date of birth of the applicant in one of the service documents have been changed from 30/2/1962 to 20/2/1962 by an officer of the respondents, which dilutes the allegation of submitting fake certificate with an absurd date of birth. My lord, the court produced the records. I was there when this matter was done before the learned tribunal. The court looked at the records. And what is important, my lord, the subsequent departmental proceeding that has been proceeded with.
Why did you say that you have never studied in that school?
No. This date 22/1962 is from the other school.
This is C1.
C1. And they changed the records. Notwithstanding the change in the records.
Change was made in the certificate Nandolal. Nandolal school certificate was 32/62.
And they are saying something. Main thing is what?
No. This writer is attributable to which certificate? To the certificate produced by you, Nandolal.
C1. C1.
No, not C1.
Yes, my lord. We also find by the records, date of birth of the applicant in one of the service documents has been changed by an officer of the respondents.
When was the certificate given by that Bihar school? না কোনটা স্কুলটা নামটা কি
পরে হচ্ছে রাজবংশী দেবী উচ্চ বিদ্যা মন্দির
ওটা পরেরটা আগেরটা কার ছিল
নন্দলাল ইনস্টিটিউট
আগেরটা ছিল নন্দলাল
My lord, lordship kindly comes to
Nandolal Institute. Kindly come to paragraph 7 of the impugned order.
paragraph 7.
It is noted by the author that his date of birth was mentioned as 32/62, which was absent. Clarification was obtained from who submitted an memo where it is a date of birth was inadvertent. Where is this certificate you have to give us?
Main problem is that the entire departmental proceeding was conducted without the originals. We made an application before the learned tribunal where we asked for production of the records. They have proceeded with the departmental proceeding without the original. The records are not there. If they can show your lordship, I'll be out of court. Let them show it. They proceeded with the proceeding totally on the basis of Xerox copies.
Application was obtained 87 from Nandulai, clarified his date should be this. Correspondence was made with Nandulal, who now this 30th of September 2012, 87 they said that there was a mistake.
Yes.
Now after, in 2012 they say had informed this after the signature, it seems to be a forged document.
Seems. That language is, it seems.
So then
And
show us those letters. Please show us the memo of 9 December 87 and 13 September 2012.
Milord, 9 December 87, no document is there. They cannot also produce.
But this was your letter, na?
No, Milord, it was
But
not.
verification was obtained from the applicant who submitted the memo of 9 December.
Milord, that document, Milord, I couldn't find anywhere. But Milord, your lordship will see the document which was there on the basis of which the charge sheet was issued. Charge memo was issued, Milord. Lordship kindly comes to
Now this page 95 which you read,
my lord.
that is attributable to which that date birth certificate? Nandalal's birth certificate.
But Milord, this is in 2014. The records have been seen in 2014 by the learned tribunal.
Right.
Now, Milord, lordship kindly comes to
this statement which you are showing us. This is attributable to the Nandalal certificate. Because
Milord,
Nandalal's
kindly comes to page 63 once. Page 63.
63. This is Nandalal. No, I am asking this statement which you have shown us.
Yes, Milord.
This is attributable to Nandalal certificate. Because Nandalal certificate said 30th February. It was corrected to 20th February.
Milord, I have a difficulty here, Milord, because the record was seen by the learned tribunal. On what basis that change?
Why we are saying changed from 30 to 20, this find supports in paragraph 7 of the original order, where you have said that a clarification when obtained, Nandalal issued a certificate saying that inadvertently 30th of February has been mentioned in place instead of 20th February.
Milord, may I tell you, Lordship, this, Milord, what I feel, Milord. The document which I have shown, page 63, Milord. It looks at page 63 once.
Page
63, Milord. This is a document of 79. This has been confirmed that he was a student. This has been confirmed. Now.
No, you said.
No,
you said I have not studied in Nandalal.
That's right. And I have studied and I have given the certificate. And it's of 79. Now, Milord, Lordship looks at where this has been evidenced, Milord. Lordship will kindly come once to that.
অর্ডারে ইয়ে করেছি।
হ্যাঁ সেটাই বুঝছি ও বললো না আমি নন্দরা
Your Lordship kindly comes to page 91.
Proceeding, page 6, paragraph C. As we do that. During disciplinary proceeding, applicant submitted on 26/2/13 that he had never studied in Nandala.
এই যে, হ্যাঁ তো নন্দলালটা নিজেই উড়িয়ে দিয়েছে
Your Lordship kindly comes to page 91.
91.
My lord.
You have a hard nut to crack, Mr. Samanto.
No, Lordship will not hold that way just now. Let me show.
91.
My lord.
Yes.
Observations, my lord. In the written statement.
What is this you are showing us? Oh,
Lord,
the inquiry statement.
Yes,
Inquiry.
yes, Lord. The inquiry officer's conclusion, etc. are there. This is, Lord, the inquiry report.
Yes.
Observations.
Yes.
In the written statement of Sri R.K. Jadhav, submitted on 26/2/2013, he accepted that he never read at Nandolal institution, which clearly means that the transfer certificate issued available with the service record is fake. As per senior DPO's letter, once a fake certificate submitted, no second chance will be given. Well, this is the main criteria on the basis of which the entire thing has proceeded. Once a certificate is issued, without considering the other aspects of the matter. This is the main reason. In fact, the tribunal also went on to hold on the basis of this notification of the railways. Now, as per Article 1 on verification of school leaving certificate of Sri Rajkumar Jadhav, done by so-and-so, it is established that the certificate is forged, fabricated and manufactured. Well, the two don't go together. I have said I have not studied. Next. On the basis of letter of so-and-so as per observation serial number 2.
Why did you say I have not studied where?
The
Article 1, you are reading that on verification of the school certificate of Rajkumar Jadhav, driver one done by S. Chakraborty, it is established that it is a forged document.
Yes.
Now you commented in clause 2 that as per senior officers 11/6/2013, once a fake certificate, no second chance will be given. This is not wrong because you yourself said I did not study in Nandolal.
Not that. It weighs without considering the next part, my lord. I am showing that. On the basis of 4.
both the school at the same day.
4.
Yes.
On the basis of the letter of senior DPO as per observation serial number 2, verification of second transfer certificate submitted by Sri R.K. Jadhav, which is issued by the principal Rajvanshi Devi Ucha so-and-so, is not to be considered, even though it has been verified by deputing Sri Banerjee. It was verified. If it is verified, my lord.
Read the next.
Next, my lord. Both the transfer certificates are issued on the same date, that is 3/2/79 from different schools, on also showing different date of birth. That is the fake one, 30, and this is 22/1962.
The same day,
date is 3/2/1979.
Date of leaving the school.
Yes. No. Both the transfer certificates are issued on the same.
School left the school on 3rd February 1979. And you come to page 63.
My lord.
Vidya Mandir Chhodne ka tithi.
Page 93.
Page 63.
63. Yes, my lord.
Page 60.
Page 60.
Page 60, Nandolal School.
Yes, my lord.
The date on which he left the school was 3rd February 1979. Middle portion. And now you come to page 63 now.
My lord.
63 is 7, item number 7.
7.
The Mandir Chodneko Tithi. 3rd February 1979.
Yes.
It is also same date.
Therefore, my lord, what I was submitting, my lord, lordship will consider what the observation of the inquiry authority.
Yes, yes.
Observation is that
You were reading clause 5.
First 4, my lord, 4. So that was submitted, that was verified, that was not considered. What is the reason? The reason is that reason is two. Once a fake certificate submitted, no second chance. My lord, the question is, why should they think of it as final that a fake certificate has been submitted? Why? I'm asking myself this question. Why they will not verify the second one? And it is verified and found to be correct. After that, I will be dismissed from service.
Then kindly clause 6.
Now, my lord.
Clause 6.
Clause 6. As per answer of PW3 Shri B.N. Banerjee, the principal of C1 stated that he cannot show any document regarding genuineness of so-and-so on 3/2/79, as all the old records are set on fire by the protesters of anti-reservation system in 1988. However, he certified the genuineness of the said TC in writing after 34 years from the issue of the certificate without seeing any previous record. But he certified it without two scales. One, fake certificate submitted. The second certificate is verified as correct. Forget about the other, my lord, 33 years, all that. Forget that, my lord. Only reason why the second thing is not being considered, that already you have submitted a fake certificate. Why that decision will be there? It overweighs the entire thing.
You are admitting that fact, Mr. Samanto. You yourself have said.
Evidence at the 35 evidence.
It was
How one headmaster can certify one thing to be a genuine without having any document?
No,
he must have admission register. He must have a register.
No, here, my lord,
the particulars of school living certificate.
Lord,
he cannot say that I am saying
this is
on the basis of to my knowledge, on the basis of the information coming on the record, based on record.
My lord, I bow down to your lordship.
Okay.
What, my lord?
Affidavit or certificate comes on two way. From my own knowledge, I know this way. And I am giving this certificate based on the information available in my office. So he must have certain record in support of his certificate.
Here, my lord, B.N. Banerjee, who had gone for that.
ও বলছে আমার সেকেন্ড সার্টিফিকেটটা ক্লজ 4 এ তুমি ভেরিফাই করে দেখলে ঠিক আছে।
এটা ওর বক্তব্য।
না এই যে ক্লজ 4
However, is certified genuineness of the said TC in writing.
না ওটা না
after 34 years.
ক্লজ 4 এ বলছে on the basis of letter of such and such verification of second transfer certificate issued by Rajbanshi is not to be considered.
Even though it was verified by deputy
certificate authenticity রেলওয়ে স্যার নিজেরাই অ্যাডমিট করে, কিন্তু ওই বেনিফিটটা আমাকে দিচ্ছে। কেন দিচ্ছে না? বিকজ অফ
ভেরিফাইড মানে হচ্ছে ভেরিফাইড টু বি ট্রু নট ভেরিফাইড
তারপরে বলছে যে আমরা ওইটাকে ফার্দার ডিলাই করব না, যেহেতু তোমার অপরচুনিটিটাই চলে গেছে টু গিভ এ ফার্দার সার্টিফিকেট। That finding is that is his argument. All right, we got your point. Yes.
Another thing, lordship, please says just before the conclusion, from entire proceedings of inquiry, it has been observed that the transfer certificate of Shri R.K. Jadhav available with service record showing date of birth as 32/62 is fake. and the date birth is absurd. The second transfer certificate is issued from principal so-and-so is also not genuine. Then, on the other hand, the established
chance will be given.
I'm sorry. There are other points also, other than this, Lord.
Why
We'll come into
chances shall be given to anyone to fill up the lacuna?
No, here, my lord, it's not a filling up. I'll answer that. I'll answer that. My lord, Lordship kindly comes to the next line. On the other hand, the establishment section of senior DPO and so also overlooked the absurd date of birth, and they all failed to detect it since long back.
No, just we are interacting. Myself, I do not find any cogent reason to accept your argument to this point. But please satisfy us as regards your second argument, that only after the inquiry officer first proceeding failed, the same inquiry officer was appointed.
Yes.
And he has
I'm grateful, my lord.
this argument that you have been prejudiced due to this ascertainment could have been made by them at the very date of entry into service. That whether the date of birth is right or wrong.
Right or wrong.
So certificate is 30th February, I will say, Mr. Samanto, this is wrong. I didn't do that. I did it only after I failed to establish my first charges. And as a consequence,
I'm very grateful, my lord. I bow down to your lordship.
This you argue before us, but that we will seek a reply from. All right, you proceed in your fashion. Next, what do you want?
Now, my lord, lordship kindly comes to that I was showing, my lord, page 95. Your lordship has seen. They have
91. You should.
95, my lord.
95 is that observation.
That.
Yes.
Because, my lord, at that juncture, they had produced the records, and that is record. Allegation of submitting fake certificate.
Yes.
Now, my lord, lordship kindly comes to my lord, in their affidavit in opposition at page 13, my lord, affidavit in opposition.
AO page 13.
Yes, my lord.
Yes, what do you want us to show?
My lord, here, middle of the page, moreover, after 7 or 8 lines, moreover.
Page
13, 1-3, my lord.
Sorry. Yes. Para 20.
Para 20, my lord. A few lines after that, my lord, 5-6 lines or 7 lines. Moreover, he also stated that the transfer certificate issued by so-and-so had submitted by his late father. And then it goes on to say, but the same is not available in the service record.
Now, this does not tally with, it should be 26th February. In the order, it is 26th February.
26.
Internal page 6, clause C, bottom line. Anyway, this was not available in the service.
And my lord, he got his service on 22/1/1980. Lordship will record it somewhere. It is there in the records, but Lordship will record it.
Appointed.
Yes, appointed
On
22/1/1980. The relevant page would be page 32 of the
1980.
1980. 22nd January 1980.
Page 13.
My lord, it would be at page 32 of the writ petition.
32 of
The writ petition.
oh yes.
Now that means, my lord, if he is born in 62, the age is below 18 when he got his service.
1 month.
So that is another factor, my lord. I'll be very humbly beseeching your lordship to consider. One, that
he was a minor.
He was a minor, number one. Number two, he's admitted that my father put everything. I signed it. It is there. I signed it. Lordship will keep that in mind, my lord. Other than the other aspects which I...
When one minor is represented by his guardian, if a guardian does any illegality, then what remedy lies to the minor? Maybe the guardian has sold out the property, has given to marriage. Then what remedy?
My lord, here I would very humbly submit, if the charge sheet was issued earlier, I could have tackled it when my father was alive.
Immediately on attaining majority, he is to point out.
But here, my lord, on attaining majority, nothing was done. After 33 years. Now, my lord, lordship.
Yes.
Kindly comes to page 110, my lord. This was the dismissal order, my lord.
110 of your writ.
A writ petition, my lord.
Yes. This is a disciplinary authority order.
My lord.
Yes.
Dated 10/2/2014. Next page. It is on the second page.
What do you want to show?
My lord, how the order was passed, my lord. My lord, second paragraph. After issuing of aforesaid SF5 on 12/12/2012, you have submitted on 25/2/2013 another attested photocopy of second school leaving certificate from Rajvanshi Devi Ucha Vidya Mandir, Thepa, mentioning the date of birth as 22/62. The said certificate cannot be accepted at this distant date, as the first has already been submitted at the time of initial appointment by the applicant and on the basis of which you were appointed in the railway service. Then kindly comes to the next page. Paragraph Roman small 4.
Roman?
Small 4. Small 4.
Small 4.
Page 111, my lord. That is inner page 2 of the order. In terms of Ministry of Personnel, Office Memorandum dated 19/5/1993, circulated via RB number so-and-so, that wherever it is found that a government servant who was not qualified or eligible in terms of the recruitment rules for initial appointment in service, or had furnished false information or produced a false certificate in order to secure appointment, he should not be retained in service and he should be removed or dismissed from service. In no circumstances should any other penalty be removed. So that is the main criteria. Earlier, my lord, they had given this point that you cannot, second certificate will not be accepted, and this is the other aspect of the matter that has been. From the above facts, it has been established
We didn't follow what you said. You was not qualified for initial and audit furnished funds. He should not be retained in service. And he should be.
There should be no other penalty. I mean to say this. There should be no other penalty. This is what they say.
What remains? What further?
No. This, I mean to say that no other consideration that you will be removed. That's all. Now, Lordship kindly comes to, so this was removed from railway service, next paragraph, Lord, from the above facts. Therefore, as a measure of punishment, you are hereby removed from railway service. Now, Lordship will kindly come to the appellate order. An appeal?
Yes.
That was pursuant to the order of the learned tribunal. Now, my Lordship kindly comes to the appellate order, my Lord. I have said that it is a terse non-speaking order. Page 118, my Lord.
Page 11.
My Lord.
Yes.
Terse non-speaking.
Yes.
And my appeal was at page 115, my Lord.
115.
115. Just
This
before.
is your appeal petition.
Appeal, my Lord.
Yes. Yes.
Now, my Lord, here Lordship will come to 115, my Lord. What the point that I had taken, the same points I had taken, my Lord. But it was never considered by the appellate authority in any manner. Terse non-speaking order. Your Lordships always say that an order should have. I've taken this point at page 4, my Lord, of the writ petition.
Yes.
Now, my Lord, Lordship kindly comes to their affidavit in opposition, my Lord. Your Lordship,
If
your
that
Lordship will
statement
think
was not there, in the light of the observation in the first round of litigation, we would not have ordered dismissal because that confusion remains. You dug your own grave. You gave a letter that no, that I didn't study that.
No, here question is not that, my Lord. Actually, what he has done is the true thing. His father gave something that Lord, he cannot be attributed anything. That could not be a reason for dismissal. My Lord, Lordship kindly comes once to the page 10 of the affidavit in opposition. My Lord, if it had happened within time, then acceptable.
Can you argue that point? Having once stated that yes, I did, you did, your stand was not that I'm not bound by my father's declaration. Your stand was I didn't
That,
study
Lord, is not necessary to be said in so many words.
If
Milord,
you
his
are
father has
giving a
died in
handle to
2000.
the authorities, they will naturally take.
No, but then how could they proceed after so many long years, Milord? That your lordship will have to also
We will
consider. Milord, lordship kindly comes to page 10.
Which page you want?
Page 10, Milord.
Yes, what do you want to show in that?
Milord, lordship, they have given this thing.
Page 10, yes.
Second line onwards. The technical snag which had taken place earlier in 2006 while feeding data in the settlement module of Prime had repeated itself. It was then decided that a clarification may be obtained from the employee regarding such an absurd date of birth of 30/2/1962. Sri Jadhav then came with a memo dated 9/2/1987, apparently to have been issued by the school Nalanda Dhanbad in the year 1987, which states that the date of birth which was inadvertently mentioned in the transfer certificate issued earlier by the same school should be read as 20/2/1962. Copy of the said certificate. No certificate is there.
No, that is X1.
No, X1 is the X1 is the transfer certificate. Where is this document?
Where is the?
Where is this document of 9/2/1987? They are saying that in 2006 they have taken my document of 1987. Where is that? I fail to understand. Lordship kindly reads the paragraph. Why? What I want to point out to your Lordship very humbly is this, Lord. Sri Jadhav then came with a, this is Lord, had taken place earlier in 2006. This is on reinstatement. On reinstatement, something happened. They could not put the feed of 30/2/1962. Then came with a memo dated 9/12/1987. That means, Lord, I had given, if at all, I had given on 9/12/1987 some document. That document is nowhere.
Now, when Kul gave his response in respect of the query made to it by the department, Nandolal institution,
Yes.
which date?
Mirror, rectified to 22/1962. That's okay. But my lord, when is this document being handed over to them? In 2006, not in 2012. And what they write after that, I'm coming to that. Here, paragraph 13. My lord, this document is not there. Kindly put a note to that, my lord. This document is nowhere, subject to what my learned friend says. Paragraph 13, my lord. Here it may be mentioned that this particular document was never produced before to the administration. Before means when? However, this document and the initial transfer certificate based on which his date of birth was recorded, both these documents were sent for verification. When? After the departmental proceeding started. I could not make head or tail of this part, my lord. I have just kept a note. I wanted to place it before your lordship. If I have given it earlier in 2006, they should have verified it earlier. Why are they sending it for verification later? There is something somewhere, my lord, I have not been able to lay my hands upon.
Yes, what is your next point, Mr. Shaw?
Page 4, my lord, of the affidavit in opposition.
Page 4.
Paragraph E. Page 4, paragraph E.
Para?
E.
Yes.
That this part your lordship has already seen, but I wanted to just. I won't waste your lordship's time. I will just take your lordship back to page 4.
So C1 was genuine.
C1 was genuine. This part I could not understand, because if in 2006 I had given a document, they are saying, I don't even remember this part. They are saying I have given a document. In 2006, it should have been clarified. They are sending it for verification when? In 2012, after the departmental proceeding. Why? What prompted them? What is behind? What prompted them, my lord?
Yes.
Now, my lordship kindly comes back to page 4 of my writ petition, my lord. Just to cut short the issue, my lord, because your lordship has heard me at great length. I am grateful to your lordships.
Yes.
First is, my lord,
Charge sheet was issued when? Can you give us the dates?
yes, my lord. Dates are given in the list of dates. Lordship will kindly take up my list of dates, my lord. It's in the application for under section 19. My lord, lordship kindly comes to page 25.
When was the second charge sheet issued?
My lord, no second charge sheet. First charge sheet.
12/12/2012. All 12.
No, the first charge sheet I am referring to your accident factor.
Accident.
Oh, that one. Just gives me a minute, my lord.
Because after conclusion, after rejection, after it was held in your favor, they commenced the second proceeding.
Yes, my lord.
So we want the date.
My lord, lordship will kindly see.
That one paragraph is there in this as a counter blast.
That is there.
The this opposition tribunal passed an order allowed the appeal in 2011.
My lord, kindly comes to page 32.
Now in 2012 you were served with a memo.
Yes, my lord.
Where is this 10th October 2012 memo? Has
My
it
lord,
been
that document, my lord, perhaps is not.
your memo?
Applicant was removed. না ওই যে আগের চার্জশিটটা আনেনি অ্যাডমিনিস্ট্রেটর রিমুভ থ্রু এ ডিসিপ্লিনারি প্রসেস
ওইটা শেষ হয়ে গেল 2011-তে ট্রাই করেছিল তারপরে এই
My lord, when they started the departmental proceeding, my lord, they have recorded that this part. Lordship will kindly come to.
the charge sheet.
The charge sheet is not there, my lord. Here, my lord, only thing, my lord, is.
No, you showed us that.
Lordship, the standard for HON'BLE charge sheet is at page 157, my lord.
140, yes.
It is at 157, my lord, of the writ petition.
না জজ সাহেব তো অন্য জিনিস জিজ্ঞেস করছেন, বলছেন আগের চার্জশিটটা।
সেটা
So 140 this letter of 10th October 2012.
My lord, lordship kindly comes to page 53 once. Page 53. They themselves record it, my lord. Page 53.
What page 50?
Lordship has got it, page 53, my lord.
Second charge sheet is page 84.
That's right. No, my lord. In the first one, page 53, your lordship will see how they started the proceeding. My lord, lordship kindly comes to page 53, a document dated Asansol, 12th November 2012. Shri Jadhav, who was removed from service, lordship has got it, my lord, as a disciplinary measure, has been reinstated and posted as TW so-and-so in terms of CAT Kolkata order dated 2/12/2011 in OA number 393 of 2007. Thence, his date of birth as per school leaving certificate appears absurd.
Now, whether any so-called notice was issued to you that this certificate is appearing, that it appears that it is bearing a absurd date.
Page 53.
And why I say page 53. Yes. Why the proceedings shall not be initiated against you?
Date of birth.
Now, what plea you have taken then? You, for the first time in 2013, in your written statement of defenses, I never studied in Nandolal. When already from Nandolal one response has come.
That response is something also suspect. I showed your lordship. If it is a 1987 document I had handed over in 2006, why it was not verified in 2006? Why it is being verified after I am reinstated? Who answers that? I am unable to.
You're taking that point because ultimately you had been the sufferer. After you give an attestation form, declaration, why the authority will doubt your statement? You are trying to draw up a linkage that you see when I filed in 1980 at the time of entry, when I was a underage. That time they accepted that certificate, I was merely doing the job. But in 2012, after they failed to establish the charge in the first proceeding, they have started.
And it is recorded, my lord, in the charge sheet at page 53. It is recorded. The intention.
For the first time 2013, he took the plea and never studied in Nandolal High School.
He has told the truth.
please come to page 196, my lord.
You're Mr.
Dotto, Ribhu Dotto.
Page 200 and
No, lordship.
196. 196.
196. Lordship, this is a letter dated 31st March 2014. This document, my lord, this will clearly show that the forgery of the school living certificate, that fact was discovered only at the time of reinstatement. Only at the time of reinstatement.
Which paragraph you want?
Lordship, kindly see. At the beginning, my lord, as regards the directive of the Honorable Tribunal, White para number 5 of the order, dated 17th February 2014.
Where you are reading?
It is at the top of the page, my lord. It is stated that no formal correction or alteration in date of birth from 30th February 1962 to 20th February 1962 in favor of Sri Rajkumar Jadhav, the applicant was made. For proper appreciation of the case, the following facts need to be highlighted. Pursuant to the order of the Honorable Tribunal in way number 393 of 2007, dated 2nd December 2011, the applicant was reinstated in his former capacity as the town of Tower Wagon Driver on 27th March 2012. Prior to his reinstatement in service in 2012, payment of his settlement dues was processed in 2006 as a result of his removal from service. At that material time, the payroll system had already been computerized. Since his particulars were not available in the system because of his long absence prior to his removal in 2002, particulars were required to be incorporated in the settlement module of Prime, that is payroll and related independent module, to make audit and payment of settlement dues. As his date of birth was recorded as 30th February 1962 in the service record under his clear signature, and the same was not being accepted by the software system, since the 30th day does not exist in the month of February, this date of birth, his date of birth was inserted as 28th February 1962, which was the last day of the month of February in the year 1962. on the February. His
He understood that. What is your next point?
next one. My lord, kindly sees record only service record once, my lord.
Pardon?
Kindly sees service record, my lord, which is at page 168 of the writ petition. Lordship, this service record is in his own handwriting. Kindly see, it has been by him, signed by him, my lord, and the date of birth he himself has written, my lord.
He's doing it.
As
When
my
was
lord,
this prepared?
Lordship, service record was
At the time of entry.
at the time of entry.
Yes.
My lord, kindly see
His
the date.
his signature is there.
It is, my lord, his signature. And, my lord, before the learned tribunal, nowhere, my lord, this point has been taken that this signature is not his own. This service record, my lord, this document remains unchallenged. The date of birth, my lord, clearly he has written in his own handwriting, my lord, 30th February 62.
It is not his handwriting, it was
Others handwriting.
maybe anyone's
No, my
handwriting.
it is-
His signature is just
He was
below that.
below 18 years. This is, but he himself wrote subsequently that I have not studied there. Then the confusion arose. Anything else? He present.
Your Lordship, kindly come. Sorry.
Yes.
And, my lord, after my learned friend finishes, I have just only small submission to me.
What? Tell us.
My lord, this is, my lord, the rules of service, conditions of service, my lord. It is at page 209, my lord. Kindly see the rule governing the recording of date of birth. Page number 209, my lord, and the rule, my lord, 225. Rule is 225. Rule number 225. It governs, my lord, the date of birth.
Yes.
My lord, the rule reads, every person on entering the railway service shall declare his date of birth, which shall not differ from any declaration expressed or implied for any public purpose before entering railway service. In the case of literate staff, the date of birth shall be entered in the record of the service in the railway servant's own handwriting, my lord.
Literate staff.
Literate.
In case of a literate staff.
Literate staff, in his own handwriting. In case of the illiterate staff, the declared date of birth shall be recorded by a senior railway servant and witnessed by another railway servant, my lord. And two, my lord, a person who is not able to declare here should be opposed. And, my lord, kindly see 225 sub-rule 4, my lord. The date of birth as recorded in accordance with this rule shall be held to be binding and no alteration of such date shall ordinarily be permitted subsequently. It shall, however, be open to the President in case of Group A and B, railway settlement.
Yes, Mr.
My lord.
Yes.
My lord, lordship kindly comes to page 79, my lord. My reply to the inquiry report.
Page 79.
9. My reply to the inquiry report.
Page 70.
Certain points are there, my lord, against serial number 8 of observation.
That is page 80.
79, my lord.
Serial 8. Oh, yes.
Serial 7. I collected the copy of FIR of the headmaster, principal of Rajvanshi Devi, logged by him on wide number so and so, and FIR of the said certificate for your ready reference, which must be collected because the loss of the documents, the FIR. So that it is that the document could have been could not have got would not have been available. That is recorded here if through an FIR, 2 FIRs. Nothing more. I should not make any further submission.
Item number 49 appearing on behalf of the appellant Union of India. Union will prefer this appeal.
Appearing on behalf of the Honorable respondent being led by Mr. Uchai, my lord.
On last occasion, my learned friend requested that they file another separate two application. That separate two application will come along with this application. This application also file another WPCT 198, my lord. That has not been come. On last occasion, that was directed, my lord. Only one application has, one WPCT has come. On last occasion, on that ground, matter was at WPCT has been filed, same cause of action, as a similar order has been challenged. WPCT in 198 2025. On previous occasion or last occasion, that matter was running in the list, and my learned friend also requested. He filed two applications. No, in this paper book,
There was a direction upon him to.
I have served already.
Oh.
But on last occasion, I also requested that it was not filed on that.
The paper book is ready.
Yes, ma'am.
Now, what you are saying, we don't follow.
Another two application also tag with this application, and he also mentioned two application. Total four application may be tag with.
What I tell you, Lordship, the order of the learned tribunal, that is challenged by my learned friend's, my lord, client, and that is also challenged by my client as well.
Oh, so what is your WPC?
So I have already, my lord, I'll just once again hand up to your lordship's officer.
Oh, how many?
So, my lord, there are two matters together.
He filed two applications. They filed two applications.
So yours one has not come.
My lord, his one and mine two did not come.
Then why you are preferring?
So, my lord, I preferred because lordship has seen the order impugned. So, my lord, there I said that the yes only, my lord, because my lord, it is already a settled situation by the Honorable Supreme Court as well as the various Honorable High Courts that the entire benefit has to be given. No capping of 3 years, my lord, has been given in any other matters. So, in my writ petition, which I preferred, rather
You are arching on. No. There is Shiblal, Supreme Court judgment, 3 years beyond his part. Interest payment.
The subject to lordship correction, it is not on interest. It is not on interest.
Not on interest, consequential.
Yes, I said that their notification itself says that I am subjected to be regularized from 1994. The Honorable High Court on the earlier round of litigation said that I will be given with the all consequential benefits. So, my lord, even in spite of that, my lord,
what has the tribunal given you?
My lord, the learned tribunal says that yes, since the Honorable High Court on the earlier round of litigation said that he will be regularized, no, he will be, my lord, said to be a incumbent of temporary status, and he is supposed to be regularized within three years. So after this, my lord, this has to be, my lord, taken care of. So, my lord, the tribunal, my lord.
So tribunal said that what benefit should be given?
I should be, my lord, given with the. I tell your lordship. I should be, my lord, given with the my lord, the consequential relief to with respect to, my lord, the payment.
The areas to 3 years.
Only 3 years. So I said, my lord, that particular benefit, my lord, the learned tribunal
Now
passed
they
the
have
order.
given notional benefit.
But they did not give anything yet because they have challenged that as well.
The regular.
No. So you are aggrieved due to curtailment of your ADRs.
Actually,
3 years.
This is my only part.
When they were.
You are being regularized from which date?
My lord, I have been regularized, my lord, since 1994.
So from 94 you will be treated as in service. So you will retire, you will get your pension on that.
Yes, ma'am.
But the areas pertaining to 94 till actual delivery will not be given entirely but for 3 years.
Yes, that has not been counted.
And my lord, my only contention before your lordship that the
when they were in RTP, the reserve training pool, that period has not been counted.
This order is passed on the basis
Give
of
your
the
number.
Yes, ma'am.
We have been informed that
direction for filing.
Three contempt matters. Can it be taken up tomorrow at 2 p.m. Milord?
Follow the list, Mr. Woodard.
Okay, sure.
One number
এই paper book
আমার
দিতে
তো
বলবো?
নাম্বার ইজ